You may be seated. Ms. Lund.
Good morning, Your Honor. Ashley Lund, to the people, Your Honor, this time you will waive any conflict between this honorable court and the office of public defender. People do not believe that any conflict exists, makes waiver for the avoidance of all doubt.
Mr. Brown.
Good morning, Your Honor.
Nice guy. I like the red.
You know, I was dressed in the dark again this morning. I don't know what. Lauren Brown, Deputy Chief Public Defender. Your Honor, we likewise do not believe that any conflict exists in this honorable court hearing these matters. If a conflict would arise, we would waive such conflict so that this honorable court could hear these matters.
Court for its part also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case, People of the State of Michigan versus Carista Riopel.
Ashley Lund, for the people.
Really?
Morning, Your Honor. Mike Geddes, defender on behalf of Carista Riopel, and I'd like to.
That's okay.
Akinruli.
Ms. Akinruli, nice of you to join us.
Good morning, Your Honor. I apologize, Judge. Yes, Your Honor, Assistant Public Defender Tanazi Carey Akinruli on behalf of Ms. Carista Riopel. Ms. Riopel, could you state your name for the record, please?
Carista Riopel.
Riopel. Judge, we are asking for an adjournment today.
Of course.
Yes, we are. I know we've asked for a few adjournments in this matter, but we have been able to meet with her. My social worker is asking for 3 weeks. He has one more meeting that he wants to schedule with her.
Probable cause conference will be adjourned May 22nd. 2025, 9 a.m. Bond will continue.
Thank you, Judge.
Thank you. Thank you, Ms. Riopel.
Right. Thank you.
Court does call the case of the People versus Walter Peterson.
Ashley Lund, for the people.
Harvard, on behalf of Mr. Peterson.
Ms. Cannon, if you had fallen, I would have just laughed. You know, I'm just gonna let you know. I would have asked if you were okay, but I really wouldn't laugh.
I would just say
We can't do it today. Could Mr. Peterson, please state your name for the record?
Walter Peterson. Thank you.
And Your Honor, at this time, we are asking that the matter be set for preliminary exam.
Discovery is all complete.
There's one last video I'm disclosing today, Your Honor. I do expect it will be complete by later today.
People would have their witnesses available the 13th.
We'll try, Your Honor.
Preliminary examination will be set in person, May 13th, 2025, 9 a.m. before Judge Valvo.
Thank you, Judge.
Bond will continue.
Thank you, Your Honor.
Thank you, Judge.
Calls case of the People versus Cameron Hanland. Excuse me.
That is for the people.
Without Swithin, on behalf of Cameron Hanland, Sandy Kumar, Cameron, state your name for the court.
Cameron Hanland. Thank you.
Your Honor, we're looking for an adjournment of 4 weeks, if we may have it. For context, this incident occurred in the context of a crisis hospitalization of Mr. Hanland's. He was then hospitalized for 2 weeks. There's records out there that I want to gather and then put together a mitigation package for the prosecutor to consider.
No objection.
There's no objection, Your Honor.
Probable cause conference will be adjourned May 29th, 2025, 9 a.m. Bound continue.
Very good. Thank you.
Thank you. Court calls case of the People versus Lozelle, Washington.
Edward for Lazar, Washington.
State your name, please.
Hello, my name is Larzell Washington, Larzell O'Neill Washington, sir.
Thank you.
Your Honor, I have a green sheet filled out there. I'm asking for an adjournment to continue negotiations. There's been an offer to a misdemeanor in this case. He does need to get screened for the 14B recovery court. It's not a contingent that he gets in, but he needs to get screened.
And that's part of the arrangement or the plea deal.
That's correct.
Part of that.
We've both signed that. We would need your signature in order to record that.
Did, do you have an estimate as to how long they're taking at this point? To do the
I'd ask for 2 weeks.
probable cause conference in this case will be adjourned at 2025, 9 a.m. bond continued.
And I would actually ask to address bond at this time.
Go ahead.
Mr. Washington was originally arraigned on March 27th. They set up probable cause conference for March 27th. He did not remember what the date was. He then did have an interaction with the police where they weren't actually looking for him, and they found out his name and located a warrant, so he was picked up. He was arraigned in this.
What kind of interaction with the?
He wants to address that.
This young lady I knew was being basically stalked.
That what?
She was being stalked and she was panicking. So I walked past her and told her, leave her alone, leave him alone before he hurt her. And so they kept asking me the guy's name. I couldn't, tell him his name. Then, the guy inquired on who I was. I normally sell ground cover news, but it wasn't no problems on my end. And I'm happy. I didn't know the courthouse was this close. I would have been down here.
So I do have a contact number for him. He indicates that he would not object to any community corrections order.
I'm not going to change the bond. We'll see what the screening reveals, and then I'll take a look at the whole package.
Okay.
All right.
Thank you.
So motion for objections denied, bond will continue.
Pete, come on, man.
Want me to do something different? Because you don't want it. Don't walk out of here like that.
Yes, sir.
Thank you, Aaron. I'll obtain a copy of that order.
Oh, man. Doing what I can to make people happy. Court calls the case, People versus Larry Hickman.
Good morning, Your Honor. Assistant Public Defender Chinasa Carey Akin on behalf of Mr. Larry Hickman.
Oh, on time. Go ahead. What? All right. Mr. Hickman there?
Yes, Your Honor.
All righty, thank you. Go ahead.
Judge, I was in communication with the people. They're probably going to file additional charges. We're not sure if it's going to be attached to this case or it's going to be a separate case. Is that correct?
That's correct. I followed up with the officer and I believe there will be sufficient charges that I'm still waiting to hear. So hopefully by that week.
So we're asking for an adjournment, Your Honor.
I do it this way then. Probable cause conference, May 22nd, 2025, 9 a.m.
Thank you.
Bond continued. Thank you. Court calls the case, People versus Shaquanda Hall.
David Knight, appearing on behalf of the defendant, Your Honor. My client is in California. She should be on Zoom, Your Honor. Thank you.
So can you unmute, state your name, please?
Shaquanda Hall.
All right. All right, what are we doing on this?
I was just retained last night, Your Honor, and would respectfully request an adjournment for the opportunity to review discovery. Thank you.
That objection, probable cause conference, May 15, 2025, 9 a.m. Bond will continue.
Thank you very much, Your Honor.
Thank you. Court calls the case, People versus John Odum.
Good morning, Your Honor. Brandon Bird on behalf of Sean Odum, PA 3734. Mr. Odum, can you please state your full name for the record?
Sean Martell Odom.
Thank you.
You're welcome.
Yes, sir.
Respectfully, Your Honor, I did get it. I know I got a motion for adjournment in there right now, but I did get a chance to speak with my client, and he'd like to set this matter for exam. I did get all discovery in this matter.
So all discovery is complete.
As far as I know, yeah.
People have their witnesses available the 13th.
We'll try our best, Your Honor.
Preliminary examination in person, May 13th, 2025, 9 a.m. before me. Bond will continue.
To address bond, yeah.
Go ahead.
Client, 40-year-old, 6 kids, 2 of them are grown. He helps raise them all. Lifelong resident Yonner. He is employed. He's trying to get back to being able to support his kids in this matter. I do understand this is a domestic violence third offense notice. My client indicates to me that he came in contact with the police because he actually went to the police station to file a report on the complaining witness. The complaining witness showed up to his job, and because the complaining witness showed up to his job, that was counted as contact. Soon as that matter happened, my client, out of his own volition, called his probation agent, to see what he should do. Probation agent told him, go to the police department and put in a report. When he put in that report, he turned around and got arrested in this matter. I do believe he was arraigned on his probation violation, in which he indicates to me that he received a $100 bond in that matter. I'm not definite, but I'm pretty sure the court probably knew about this case when they gave him that $100 bond, because this case stems back from March 28th, Your Honor. Respectfully, my client understands no contact with the complaining witness. At this point, he doesn't want any contact with the complaining witness. He didn't want contact with the complaining witness when he came into contact with her at his job. So respectfully, we're just gonna ask for a personal bond. My client doesn't mind the tether if we have to do a tether. This is a relationship where both of them need to stay apart from each other. He was doing his due diligence to stay apart from her. And just respectfully, Your Honor, we're requesting a lower bond, hopefully a personal bond, so he can at least get back to work and take care of his children, Your Honor.
Response.
Your Honor, I would strongly object to any change in his bond. I believe it's set at 50,000 cash surety at the moment. Mr. Odum has a lengthy history of dismissed DDs as well as DD conviction from just this year, with the same victim for a DD second, which is pled down. He's currently on probation for that and violated his probation with getting this new case. In the report for his bond violation, the victim informed officers that she let him borrow her car because he had nowhere to stay. She asked for the car back. He came back to her house and was yelling at her. And she also stated that he pulled out a knife while he was there. So I have great concerns that he can't follow court orders and wouldn't keep getting in contact with the victim and wouldn't be able to stay away, given that he's already on probation for the amount of times with the same victim.
Yeah, and there's ways to mitigate these circumstances. And the way we can mitigate that is with a tether. Obviously, the
I don't
complaining
know that a
witness is
tether
coming in
stops a knife, but go ahead.
I'm not saying the tether stops a knife, but at least it'll let you know if he's around the complaining witness. And if he was there and they could come get him right away.
And Your Honor, I did also want to inform that previous case that was pled down was a previous FA with the same victim. And then in the underlying case of this case with the same victim, he grabbed her by her hair, pulled her into the living room, a fighting suit, and in the process of that, he hit her child in the face. He punched him, leaving him with a black eye. That's the underlying case that was out on bond for. So I have great concerns.
And that he's still innocent unless proven guilty beyond a reasonable doubt to, Your Honor.
Motion for bond reduction denied. Bond will continue.
Thank you for hearing me out. You know.
Okay. Court does call the case People versus Theophilus Smith.
Andrew Childers appearing on behalf of the people, Your Honor.
Kelsey Virgils with and on behalf of Theophilus Smith, who appears via Zoom. Mr. Smith, please state your name.
My name is Theophilus Smith, Judge Simpson, and I would like to speak today because what's going on in this jail, Judge Simpson, is a prime example of the paper I wrote when I was at Michigan State University.
Mr. Smith, I would advise you to not speak at this time. Mr. Smith, just let us handle the matter, please. Your Honor, I provided the court with an order Mr. Smith met with the forensic center who deemed him incompetent but restorable. We have no objection to those findings and ask the court to give him time to be potentially restored.
Any additional information from the people?
No, Your Honor. The people would stipulate to the report as well. Thank you.
All right. Court, upon reviewing the report, would find at this time he's incompetent to stand trial, but likely to attain competence, provided the course of treatment. Given that, the court will sign an order to that effect. And I've signed that order. I will adjourn this for a competency review to 90.
Judge Simpson.
I'll set a competency review for July 30th. July 31st, 2025, 9 a.m.
Okay, can I speak with you now, Judge Simpson?
Mr.
Can
Smith,
you what?
I need to speak with you because I need to ask you some questions. I know they deem me incompetent, but Judge Simpson, my safety is at threat in this jail. I'm strong. Judge Simpson, they've been breaking me down mentally, physically. They've been stripping me of my dignity. The COs and the inmates are in cahoots.
Okay, Mr. Smith, Mr. Smith.
I need Judge.
Okay, just listen. Hey,
Judge Simpson.
hold on.
Yes.
I've given you another date. You're gonna get a chance to come back and talk, okay?
Yeah, because it feel
But
like.
right now, you're gonna have to talk to some other folks.
I'm out today, you said, Judge Simpson?
What'd you
Judge
say?
Simpson, excuse me, sir? Yeah, I'm strong. I'm out today.
No, not today.
Mr. Smith, you're gonna,
Judge Simpson, what this jail is doing, they trying to accept Judge Simpson. Believe what I'm saying.
Mr. Smith, you're gonna get some mental health treatment. Please call the public defender's office.
All right, Mr. Smith, contact your attorneys and we'll see what we can do, okay?
How long do I'm not even suicidal, Judge Simpson. They got me in the.
All right, Mr. Smith, I'm done.
Judge Simpson.
Thank you.
I'm not gonna do nothing about my.
Thank you, Mr. Smith.
I can't even call my mom. They got me in the suicide.
Court does call the case, People versus Amanda James.
Andrew Childers appearing on behalf of the people, Your Honor.
And good morning, Your Honor. May it please this honorable court. Oh, well, I'll yield the floor to someone. Oh, okay. Good morning, Your Honor. For the record, Rita Young appearing on behalf of Miss Amanda James, who is present and standing to my right. And today is the date and time set for a probable cause conference, Judge. And there has been an offer made. I don't know if the court's received the printout yet.
I have. I've received a plea sheet that indicates she's going to be pleading to 3 misdemeanor charges.
Yes, Your Honor.
The stated count 3 of operating with the presence of a controlled substance, the crime of operating either with no license or multiple licenses, that's count 4. And then also an added count 5 of use of a controlled substance, a 1-year offense. On her successful plea to those guilty plea to those charges, counts 1 and 2 would be dismissed. That is the court's full understanding of the agreement.
And Judge, there was an agreement by Mr. Childers and myself that she could be sentenced under 7411, but the plea form indicates it's only applies to count 5. And I asked that he agreed that it also apply to count 3, which is the presence of.
And Your Honor, it can't, as the court's aware.
Yeah, I didn't.
7411 doesn't.
I don't think it can.
Very well done, Your Honor. I believe that my client wishes to proceed with the offer. She has been advised.
Did she sign an advice rights form?
No.
All right, I'll get you to sign one.
Your advice, we went over. Just sign.
With
Yep.
Let's have her sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth.
I do.
State your name.
I'm Anthony.
Ma'am, it is this court's understanding that you're going to be pleading guilty to 3 charges. Is that your understanding?
Sure.
All right. First of all, that you'll be pleading guilty to the charge of operating with the presence of a controlled substance. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle mobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
All right. Also, then count 4, operating with no license or multiple licenses. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. You understand that?
Yes.
And then also the added count 5 of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you'd be sentenced before Judge Barr in the 14A2 District Court. You understand?
Yes, sir.
All right. Now, understanding all of that, ma'am, do you still wish to plead guilty to these charges?
Yes, sir.
To the charge of operating with the presence of a controlled substance, how do you plead?
Guilty.
To the charge of operating with no license or multiple licenses, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights for every day, is that correct?
Yes.
Any question regarding any of those rights?
No.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights that are on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes.
because you believe that you're guilty of these charges?
Yes.
On February 9th, 2024, at the location of Ann Street in the city of Ypsilanti, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes.
Was that cocaine?
Yeah.
All right. Were you stopped by the police or was there an accident?
I was approached by the police while airing my tire. I'm not sure if they seen me exiting my vehicle prior to them approaching, but
They approached you because there was no air in your tires?
I was pulled over on the side of the.
Side of the road because your tire had gone flat? Okay. And after they approached you, were you ultimately arrested?
I was detained, yes.
Pardon?
Yes.
All right. Were you taken to the hospital for a blood draw?
Yes.
Did that blood draw show the presence of cocaine and or its derivatives?
Yes.
All right. Do you have any reason to dispute those blood test results?
No.
All right. And at the time that you used the cocaine, you knew what you were using was cocaine?
Yes.
Pardon?
Yes.
All right. And at the time also that you operated the motor vehicle, did you have a license?
No.
Okay. Never had a license?
I've had a license. It was just a.
But at that point, had no license.
Correct.
Correct. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report as well as screening assessment is ordered at 14A2 probation. Sentencing will be May 14, 2025, 10 a.m. before Judge Barr.
May I address bond, please?
Can I stop you? No, go ahead.
Of course you can. Miss James, she's 45 years old, Your Honor. She resides at the address that's listed in her file. She's a certified nurse assistant and provides home care to a patient that she's had for 7 years. Her bond is currently set at 10,000 cash or surety, and that was because she appeared by Zoom for a probable cause. No, she appeared by Zoom for an arraignment and then thought she could appear by Zoom for the probable cause conference, was told that she could not make it to court in time. Her attorney was not able to get a new date, so the bond was increased to $10,000 cash as surety. We're asking the court to please reinstate her $5,000 personal bond, which the court set on July 9th of 2024.
How did she come into custody?
Driving without license. When the police came into contact with her, when she had pulled over and was filling up the tire on her.
No, just recently.
No, but then
When were you arrested the last time?
How did she just
brought
recently
in.
come into custody?
I was-
She didn't come immediately back to the court.
Yeah, no, I was in a vehicle.
No, Your Honor, she did not. She said that she thought that her attorney at that time would be able to get her a new PCC date, but then her attorney withdrew. And then I was assigned on January, I think it was 9th of 2025. And then that's when she had been taken into custody around sometime in January.
No, I just came.
No.
No, I was in a vehicle that was pulled over.
So, and it was pulled over?
Yes,
And you knew at the time that it was pulled over that you had to show up for your court date?
yes, I didn't.
So why didn't you come in?
Well, I did. I came in
Well,
with that.
now, yeah.
Yeah, well, at the time prior to me being pulled over, the attorney I had, Chelsea, I can't think of her last name, she's a public defender. She advised me originally, I was on the phone.
She
with her
advised you originally?
to not come, to not turn myself in.
Oh, really?
She did. And then
She
she
did?
quit.
So she told you,
And then
yes,
she-
don't come to the court
Until after Christmas.
until after
Yes.
Christmas.
Yes, and then she quit.
Why would she say that?
For the same reason that she wouldn't tell you I was on the phone with her while she was here in court.
Excuse me? Oh, she was just out to get you.
I'm not saying she was out to get me. I'm saying that
She wanted
there
you
was
to
just
spend Christmas.
miscommunication. There was a
So
miscommunication.
she told you not to come in until after
She
Christmas?
told me to hold off on turning myself in.
Till after Christmas? Right?
Her words were,
I'm now on May 1st. When did you get picked up?
9 days ago.
9 days ago? That's well after Christmas.
Yeah. Well, she had quit, Your
So,
Honor. I didn't
other
have
than the
enough.
other false statement you made about Ms. Vergil, are you saying she told you to stay out till that point too?
I didn't have an attorney.
Oh,
I was informed by the.
oh, you're
Judge,
just put
I
on that
think she was-
device? Yeah, okay.
Yeah, Your Honor,
I think
don't
she
wanna
was
make-
taken into custody before then because they would not have assigned me. I have proof that I was assigned on January 9th of 2025. So,
So where's she been since January 9th?
were you released and then failed to appear again?
I can explain to you after.
And then 9 days ago, she gets picked up.
Judge, it's kind of bizarre what's been going on.
Pardon?
It's a little bizarre what's been going
Oh,
on.
yeah.
with the Case,
have-
and we both apologize,
Yeah, okay.
but she has one prior conviction that was in 2025 years ago,
Don't
Judge.
blame, you know what?
I'm not
Here's
trying
my
to
problem. I almost would buy your story, but
I'm not
you're
trying to
not
blame.
gonna blame Ms. Vergil for you
But
not
no,
appearing. You
I'm
decided
not.
that you wanted to stay out, you wanted to
I
be
did.
out till Christmas. She did
I
not
did.
tell you that,
No,
and then
I'm-
you just continued to stay out. So
Yeah, I'm not
motion
trying
for
to
bond
blame.
reduction denied, bond will continue. Thank you.
Very well, Your Honor, thank you.
Ms. Vergil, that was so nice of you to make sure she could celebrate Christmas. Court calls the case. People versus Saratti.
Good morning again, Your Honor. Uwe Daus with and on behalf of Mr. Abadi, standing to my right. Cyrus, please state your name for the
Good
record.
morning, Your Honor. Cyrus. Thank you.
For one, Your Honor, I do have a green sheet for a PCC adjournment. I don't think there's an objection to that, just didn't get submitted yet. We were looking for 22nd, I think, 3 weeks.
So you're picking your dates?
I am not. I'm
Yes, you were.
expressing what I'm looking.
Yes, you were, Mr. Public Conference, May 22nd. 2025, 9 a.m. Bond continued.
Your Honor, may I address bond briefly?
Okay, yes.
I am covering this case for APA Canada, and I am requesting, an additional bond condition for no go to. The victim in this case was University of Michigan, and my understanding is that the defendant does not, he goes to the Dearborn campus, but might be present here for social events and things like that.
What kind of social events?
Perhaps, once Ms. Willenbring is finished, perhaps council may approach about this.
Does he live in Ann Arbor?
Yes. I answer.
Does he have a reason to be on campus?
Yes.
Okay, go ahead, Ms. Williams.
Yeah, so in order to facilitate the no conflict further, I think it'd be appropriate for a no go to for the main campus, since the victim goes to school there, the defendant does not. So that's my request. I don't know if the defense would like to put something else on the record as far as the social events he needs to attend on main campus, but.
Again, my first request before I respond on the record would be to approach Judge, maybe.
Yeah, you can approach.
Thank you. To the requests made by the people, not necessarily on substance, but on form. There have been prior communications with Ms. Tanner about this on April 10, again on April 15. There has been no response to this. If the people wanted to add this condition, our request would be for this to be done by written motion to which we can respond in writing.
Right, so, fine. Here's what I'm gonna do. I'm gonna grant their request. Defendant is prohibited from the main campus of the University of Michigan. If you wish the court to reconsider that, we'll be back on the 22nd. File your motion and I'll take a look at it, Mr. Dawes.
Understood. Thank you.
Calls case, People versus Rashad Hall.
Alexander, on behalf of people.
Sorry. When you broke up there, can you state your appearance again, please, sir?
Christopher Quinn, appearing on behalf of Mr. Hall.
All right. Your name, sir?
Shar Hall.
All right. What are we doing today?
I'm in receipt of some jail calls. I need to go over those with my client, Judge. I just need another PCC for May 8th, if that's available.
Just want to pick your date. Fine. All right, that's fine. What? I don't have May 8th. I have May 15th. I can do May 6th. I can do May 6th or May 15th.
Let's see, May 6th, Judge. Yeah, May 6th, I will be in your courtroom, Judge. That works for me, May 6th.
You're going to be here?
Yeah, I'll be in person, Judge, of course.
Oh, boy. All right. I'll adjourn probable cause conference into May 6, 2025 at 9 a.m.
Okay, thank you, Judge.
Thank you. Bond continued. Court calls the case, People versus Kevin Barajas Vargas.
Hey, good morning, Your Honor. Laura Yagi, Assistant Public Defender with and on behalf of Mr. Barajas Vargas. Could you state your name for the court?
Kevin Barajas Vargas.
Your Honor, in this matter, we are requesting a preliminary examination date. I would ask to address bond.
Of course you would. Is all discovery complete?
So the only question I had, and I emailed Ms. Tanha about this, we requested the 911 call last time. I'm not sure. I was just trying to see if we got it through on base. But I feel confident that we'll be able to get it before the exam.
All right, there will not,
Thank you. Appreciate
there
it.
will not be an adjournment for that purpose.
Understood, Your Honor.
So people have their witnesses available the 13th. Preliminary examination in person, May 13th, 2025, 9 a.m. before Judge Valvo. Yes, Esteban.
Thank you. So in this matter, my client is prohibited from contacting his 3-year-old daughter as well as his mother and his daughter's mother. He is charged with count 1, which is the felony child abuse. For the allegation is throwing his daughter out of the door. That being said, the CPS investigation has now been closed. The body worn camera shows, and I know, it's not a trial date today, but that even the daughter's mother, denied even a medic to look. She said she's fine. She said it didn't happen when the daughter was trying to tell the police what happened. There's a lot of issues here. My client is even willing to do any sort of supervised visit, if the court would even allow that to allow him to contact his daughter. This is the longest he's gone without even seeing his daughter in her entire life, and it's really difficult for him. So that would be our main request as to bond modification.
Response.
Your Honor, contact with the child victim is simply not appropriate at this time. He was 3 years old, and the report states that
Phase 4.
when they were co-parenting, him and the mother of the child, and when they showed up, he was yelling at the mom, asked her to leave, pushed her, and then he grabbed the 3-year-old child under her armpits and threw her from inside the house, outside the house, and she landed on her back and was screaming and crying. I don't think it's appropriate for him to have contact, even supervised contact at this point during the pendency of this case, which is charged as a child abuse murder.
Anything else?
I think the only difference between his initial arraignment and now is we have the body worn, which shows that the mother said, basically denied the child's allegation. She said there's no injuries, no need for anybody to look at her. She's completely fine. CPS has now closed the investigation when my client signed a safety plan with them. So I think it is excessive for him to not even be allowed to have any contact with her whatsoever, not even a phone call. This is, so I would submit on that.
I'm going to wait for the point at which there's testimony, or at least Judge Valvo can look at it. So at this point, motion for bond modification is denied.
Thank you, Your Honor.
Court calls case People versus Jacob Dorston.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Dorston, who's here to my right, Judge.
Your name? Jacob John Dorston. All right.
Your Honor, I've had a chance to discuss this matter with Ms. McDuffie and with Mr. Dorston. Our office is still in the process of preparing mitigation materials for the prosecutor's review. I'd ask the court for a brief adjournment to allow us to accomplish that.
I have a green sheet.
I turned one in.
Okay, we'll find it. Probable cause conference. Have they started the mitigation?
Yes, Your Honor. They've met with him. They're drafting it.
May 15, 2025, 9 a.m.
Thank you, Judge.
Bond continue. Calls case People versus Todd Ammerman.
Lord Yaki, Assistant Public Defender with and on behalf of Mr. Ammerman. Mr. Ammerman, could you state your name for the court, please?
Todd Ammerman.
Okay. Your Honor, I do have a green sheet, sorry, in this matter. I am requesting a 1-month adjournment for continued discussion regarding plea as well as mitigation.
Any objection from the people?
Okay.
Probable cause conference, May 29, 2025, 9 a.m. Bond continued.
Thank you.
Court calls case People versus James Jantz.
Actually, like the people.
Brian Bowling on behalf of Mr. Jinx, Your Honor. Or Jantz, I'm sorry. State your name for the record, please.
James Jantz.
Thank you.
Your Honor, we're asking that this matter be set for an exam. To my knowledge, all discovery is complete.
People have their witnesses available the 13th.
Checking out, we can try for that date, Your Honor.
Preliminary examination in person, May 13th, 2025, 9 a.m. That's before me.
Thank you, Your Honor.
Bond continued. Thank you. Court calls the cases of the People versus Aurelio Beavers. Both on.
And Assistant Public Defender, Chinazza Perry, Your Honor, on behalf of Mr. Aurelio Beavers is approaching. Mr. Beavers, state your name for the record, please.
My name is Aurelio Shantes Beavers.
All right, hands out of your pockets. Thank you. All right, what do we do?
Your Honor, we respectfully request that both of these matters be set for preliminary examination, please.
And discovery is complete on both matters.
To our understanding, Judge.
People have their witnesses available the 13th. May 3rd, preliminary examination, May 13th, 2025, 9 a.m. before Judge Valvo.
Thank you, Your Honor.
Bond will continue.
13, okay, step up. Okay.
Court calls case People versus Scott Jinx.
As then we have to.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Jenks, who is approaching the podium. Please state your name for the record, sir.
Scott Jenks.
Thank you.
Thank you, Your Honor.
Good to see you, Ms. Pate.
Good to see you too, Your Honor. Your Honor should be in receipt of a green sheet. I have discussed this matter both with my client and the people. I believe we will be reaching a resolution in this case. We just need to speak to or confirm with the officer in charge. I'm requesting just 1 to 2 weeks. And I am not going to be addressing bond today, however.
No, go ahead.
I'm not going to be addressing bond today per se, Your Honor, except to say I have discussed this briefly with the people as well as my client and his daughter who is here today in the courtroom. We're trying to find a place that he could stay during the pendency of this case. As of right now, we don't have that ready yet. So I do believe if we are able to get that locked down, we will be filing something with Your Honor, but we will not be addressing bond per se today, but would be respectfully requesting a 1 to 2 week adjournment.
All right.
And that's correct, Your Honor. I did send an email to the officer in charge yesterday, and I'm just waiting to hear back regarding the offer.
All right. We'll adjourn this then to May 15th, 2025, 9 a.m. Bond will continue at this time. All right.
Thank you very much, Your Honor.
Thank you. Calls case People versus Leslie Brown.
Good morning, Your Honor. Sam Bernstein with and on behalf of Leslie Brown. It's good to see you, Your Honor.
Your name, sir?
Leslie Brown.
Thank you. What are we doing?
Your Honor, could we please have an adjournment to review discovery?
Probable cause conference, May 15th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
I need a green sheet. Court does call the case People versus Richard Johnson.
Rachel McGuffey, people. The public defender again, hearing on behalf of Mr. Johnson, approaching now. Mr. Johnson, can you state your name for the record?
How you doing, Your Honor? Richard Johnson.
Thank you.
Your Honor, we do have some outstanding video discovery. We'd ask for an adjournment.
Probable cause conference, May 15th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Thank you. Case People versus Cassandra, is it Bohr or Bore?
And Assistant Public Defender Jay Bellinger on behalf of Ms. Bohr, who approaches, Your Honor. Good morning.
Good morning.
And Your Honor, I have talked to Ms. Bohr. Can you please state your name for the record?
Cassandra Ambbor.
Your Honor, I have spoken with prosecution about this case. We were just asking for a couple of weeks as we work out the negotiations.
Got objection, probable cause conference, May 15th, 2025, 9 a.m. Bond continued. Thank you.
All right. Thank you.
Court calls the cases of the People versus Jacqueline Jones Washington.
Brian Bowling on behalf of Ms. Jones Washington, Your Honor. Can you state your name for the record, please?
Jacqueline Jones Washington.
Judge, I submitted finding an order on competency documents this morning in these matters. My belief or my understanding is the court previously found Ms. Jones Washington incompetent but restorable.
Correct.
But from what I could tell from GIS, those and a letter that was received from the Department of Health and Human Services.
Orders weren't.
That's correct. So I rectified that problem. And so I'd ask you to sign those and then
I'll sign those and then once I'll then set this out for a review now that everything's in place till July 31st, 2025. 9 a.m.
Thank you, Your Honor.
Thank you. Thank you. We'll continue. So we don't have this again. You said that. Court calls case People versus Elton Bell.
People.
Assistant Public Defender Chelsea Vergils on behalf of Elton Bell. Your Honor, he called me this morning and said that his ride was late. I believe he's on his way here. Would you mind passing it so I can call him? I did speak with him this morning.
Did?
Yes, and I would greatly.
Tell him he didn't have to show up till Christmas? No, I'm kidding. I'm sorry. Sorry, wrong case. Go ahead.
I would appreciate your consideration in allowing me to please call him.
Okay, because I said that, I'll pass it.
Thank you,
That
Your
was
Honor.
bad of me. Court does call the case People versus Danielle Clayola.
Andrew Childers appearing on behalf of the People, Your Honor.
And Assistant Public Defender Chinasi Carey, Your Honor, on behalf of Ms. Danielle Clayola. Danielle, state your name for the record, please.
Danielle Claymore.
We're asking for the adjournment today. We are working on getting Ms. Clayola into the 15th District Sobriety Court. They are working with CMH in regards to her medication management, just to ensure that she's going to be eligible to enter. But I think everything else is still on board. We're just
Well,
2 more weeks.
2 weeks.
Yes.
Enough time to
I
get
think
that
so.
information.
Yeah.
Probable cause conference, May 15th, 2025.
Thank you, Judge.
Thank you.
Okay, see you.
Case People versus George Bowman.
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Bowman, who's approaching judge. State your name, sir.
George Bowman.
Go ahead.
Your Honor, I have prepared a referral form for the Circuit Court, Sobriety Court. I'd ask the court to adjourn this to allow Mr. Bowman to be screened. I thought there was a place for you to sign, but there does not appear to be one. I have discussed the matter with Ms. Londi, and she's in agreement.
Probable cause conference, May 22nd, 2025, 9 a.m. Okay.
Thank you, Judge.
Bond continued. Thank you, Mr. Bowman. Yeah. Okay. Court does call the case, People versus Dale Miller.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Miller, who's approaching now. Mr. Miller, will you please state your name for the record?
Dale Miller.
You're requesting forensic evaluation.
Yes, Judge, you previously signed an order on the 24 cases, when Mr. Miller was in Wayne County. However, the 25 case, we do need an order signed, and he is scheduled for an evaluation this week with the Forensic
Yes.
Center.
What date did we give you on the other cases?
I don't think we had a date set because he ended up having a warrant issued. Wayne County released him without transferring him back here, and a warrant issued, and
Okay, so there's no dates.
no date, yes.
All right, so are we gonna need new orders on all of them or no?
I don't believe so, because the Forensic Center had received them, contacted our office with a date to schedule. I let them know that he's back in custody. They said that they coordinate with the jail, so I think that the other orders are
Gonna be good.
still.
All right, then I'll leave those in place. I'll sign this new order. We'll set a competency hearing for July 31st. Well, no, give me 16, July 16. July 3rd, 2025. All right, thank you.
Thank you.
Court does call the case, People versus Grace Brenner.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Brenner, who should be appearing via Zoom. Ms. Brenner, will you please state your name for the record?
Good morning, Your Honor. My name is Grace Brenner.
You got her?
Thank you.
All right, go ahead. You're requesting an adjournment.
Yes, Judge, and then may we approach?
Okay, come on. We're back on the.
So Judge, thank you for the bench conference. If we could have maybe 3 or 4 week adjournment, just so that we can retrieve the phone and have those conversations. Thank you.
Probable cause conference, May 29, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. Calls the case, People versus Rahman Mohammed.
Brian Bowling on behalf of Mr. Mohammed, Your Honor.
Mohammed.
Your Honor, I'm asking for an adjournment in this matter. We're still waiting for some video. I did reach out to Ms. McDuffie, and I believe she's working on it on her end, and hopefully we should have it soon.
Probable cause conference, May 15, 2025, 9 a.m.
Your Honor, may I address bond?
Yes.
Your Honor, it's come to my knowledge that Mr. Mohammed has a no bond warrant that was issued by the ATF that he would like to be picked up on. It's also my understanding that he has a couple cases up at the circuit court pending before Judge Hamoud, and she granted him personal bonds on those matters for that purpose. I'd ask the court to consider doing the same in this case.
Why would they do that?
We could go address the federal matter and then ultimately address these matters.
Yeah, but then he doesn't come back here. So why don't we address these? And he can go address.
So these matters would affect his federal sentencing guidelines, which could impact him negative
No,
at
I
that, in
understand.
that system.
That means, that seems to me that means you deal with these and then go deal with the feds.
I think it would be a better idea to deal with that one and then deal with these.
You know, I rarely would disagree with Judge Mood, but I'm not gonna do that.
Okay.
So your motion for bond reduction is denied. And a changing bond, and his bond will continue, and we'll see everybody on the 15th.
Thank you, Your Honor.
Calls the case, People versus Desmond Burke. I appreciate that. You know, we can get you one of those with a point on the end.
Assistant Public Defender Chelsea Virgils with and on behalf of Desmond Burton. Mr. Burton, please state your name.
Desmond Ashton Burke.
Thank you. You're requesting it?
Yes, requesting an adjournment for discovery, video discovery.
Probable cause conference, May 22nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Pardon? Oh. Court calls case People versus Timothy Stevens.
And was that on behalf of the people?
All right, thank you. Lord Yagi, Assistant Public Defender, with and on behalf of Mr. Stevens, who's approaching. Mr. Stevens, could you state your name for the court?
Timothy Stevens.
Thank you.
Your Honor, in this matter, we are requesting that this be set for preliminary examination. There's no offer available at this time. I think the only question I had, and I'm not 100% sure, is the 911 call, but if we don't have it, I feel confident we could get it before and we may have it through on base. I wasn't 100% sure, so.
Sorry, I don't believe there is an actual call.
Okay.
It's a walk-in report, so I don't believe there is.
Oh, that answers that. So then, to my knowledge, discovery is complete.
People have their witnesses available the 13th.
We'll do our best, Your Honor.
Preliminary examination in person, May 13th, 2025, 9 a.m. That is before me.
Your Honor, I would ask to address bond briefly.
Okay.
Mr. Stevens' mother is in the courtroom. We are asking for a 10% provision on his bond. This, obviously, the allegations in this case are very serious. However, usually with these types of charges, there's an allegation of a violation of a court order, and this is not one of those cases. So there is no evidence or allegation that Mr. Stevens violated a protective order or a court order prohibiting him from having contact with the complaining witness in this case. So I would argue Mr. Stevens will abide by court order. Now there is a court order obviously prohibiting any sort of contact. Mr. Stevens does not live with the complaining witness. He has his own residence. His mother is here in the front row to support him, to offer her support. He doesn't live with her, but she indicated to me on the phone yesterday she would provide support to him. He also is going to sign a release of information. He reached out for mental health treatment prior to his arrest, but he wasn't really in as intensive treatment as he needs. And everybody, including his mother and himself, acknowledges that he needs mental health treatment and he wants it. And he'll do anger management, he'll do counseling, he'll do therapy, he'll do his medication regimen. He'll also wear a GPS tether to provide additional security.
But I mean, has treatment been set up for him?
So he reached out prior to his arrest. I have not received any paperwork, and I'm hoping he'll sign this ROI so that I could try to verify that he did reach out and complete the first step of the process. So he did give me the specific names of people that I verified work at this organization. So I think that was in the process of it was in very big.
I just wanted to make sure I wasn't clear on that. All right. Yes.
I have a strong objection to any change of bond. We originally requested in this case $100,000 cash surety. I would be reviewing that request at this time. In this case, they dated 8 months. She left him after a domestic violence incident where he strangled her. After that, he was calling, texting her. on different platforms. She made it explicitly clear that she wanted no contact with him. He was seen on her home security at her house for an hour, in which he drove from his residence in Romulus to her residence in Saline. So I have great concerns about that he would drive that far of a distance to go to her house on a couple occasions. And then in these messages, I have severe concerns for her safety, his safety, and the community's safety. He was saying things of the nature, I promise I will effing make sure that this baby does not make it to this earth. All I effing ask of you is just to talk to me, and you can't even do that. You're a effing non-excusable woman. I'm legit going to heaven or jail this weekend, so I'm about to enjoy it. I swear to God on my life, if you have another man in your phone, I will take this too far. He said, you think your door will stop me, call the cops on me, and you better expect some repercussions. You call the cops on me, I'm coming in your effing house. I might want to answer the effing phone before I drive the F down there and break your effing skull open. I'm not effing playing with you. I'm about to catch some effing charges. And then in these messages, he also sent a video of him with numerous pills threatening to kill himself, and then also a video of him speeding over 100 miles an hour on the road to her. So I have great concerns for his safety, her safety, and the community safety, and have extreme concerns with this case, and will be asking for our request for $100,000 to be reconsidered on his bond.
What are you?
May I respond, Your Honor?
You may.
So clearly he's in jail. I have not received any allegation of a bond violation. He is held on this bond. So I would argue there's absolutely no reason to increase his bond with there being no bond violation. There's no basis for an increase in his bond at this time. There's no bond violation. He is held in jail. He can't pay his bond as it is. So there's absolutely no reason for a bond increase without a bond violation. Furthermore, he's not charged with assault. I know the messages are very awful, but he's not actually charged with any assault. He's not charged with strangulation. He's not charged with domestic violence, nothing. So his charges are based on these messages and malicious use of telecommunications device, obviously. So I just want that to be clear because obviously I think this would be a different case if he was charged with assault.
And I just want to bring the court's attention. The victim informed officers when she reported that the DV incident, the strangulation, occurred in Romulus. I'm not sure if any charges have come from that in Romulus, but
The DV.
the incident that caused their breakup that led to these texts and calls.
So, right, so when was that alleged to have occurred, do you know?
I believe it was late February, early March, is when that incident, she said, occurred in Romulus and his residence.
Council approach. So that occurred in February, March, then these charges arise in April.
Correct.
We don't know if the charges in Romulus have what's happened yet.
If there were charges, I'm not sure you're.
My information is that there's no charges based on that.
Part of my concern is that I'm not clear, given those factual allegations, and I realize there's a presumption of innocence certainly in this case, but given the nature of the charges and what was just relayed to the court, which are sort of at the base of these particular charges. I'm not sure how we got a $5,000 cash surety bond. I don't, I'm having great trouble with that as to how the bond got set where it is in the first place. Anything else you want to say?
Well, just that I would argue that the court shouldn't increase his bond with no bond violation because it is, it is resulting
I
in.
think that his bond is initially set is absolutely inappropriate just based upon what I've heard here. I mean, I think with the facts that I've heard, with the nature of the charges and everything else, if necessary, I mean, I'll just make the finding. I think it's an absolute abuse of discretion that the bond got set where it is out of the gate. So, I'm going to increase the defendant's bond. I'm going to deny the defendant's bond request. I'm going to grant the people's request that the defendant's bond will be increased. His bond will be increased to 50,000 cash surety. I won't send it up as much as they want it, but I think that where it's set now is absolutely inappropriate. Thank you. Case of the people versus Dion Bird.
And then on behalf of the people, Your Honor.
Stephanie Cannon.
I need that.
All right. Certainly, you're present, please state your name for the record.
How you doing, Dion Bird? I'm doing great, thanks.
At this time, the people are unable to proceed as to be remanded to district court.
Okay. Got it. Hold on a second. I just want to make sure I get this. So count one would be dismissed. He'll maintain his not guilty plea. As to count two, I'll set a pretrial in that matter. May 15th, 2025, 10 a.m. before Judge Barr.
Your Honor, my client has informed me that if possible, he would ask for this to be moved to a different date. He's already has a court date, a show cause
So he's gonna have to,
with the friend of the court.
he's gonna have to deal with 1482 to move the date.
Okay.
I think that's the only date I have. That's the only date I have.
Thank you, Your Honor.
Thank you. Thank you. Court calls case People versus Davion Thomas.
Andrew Childers appearing on behalf of the people.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Thomas, who's making his way to the podium, Judge.
Go ahead.
Your Honor, there was a bench warrant issued in this matter. Mr. Thomas did turn himself in Tuesday. Tuesday. I've had a chance to discuss this matter with Mr. Childers. I believe that we're going to have a resolution involving a misdemeanor and no objection to HIDA on this. This is so I'd ask the court for a brief adjournment of this probable cause conference so that we can get the paperwork together. I'll do a green sheet immediately after we do this hearing.
Couple weeks.
Yeah, that would be fine, Judge.
Probable cause conference, May 15th, 2025.
If I could be heard on bond. Your Honor, Mr. Thomas is here. There was a bench warrant issued for failure to test. Mr. Thomas, he had gone on a family vacation. He came back. He injured. He works at Amazon. He injured himself at work. He had a medical appointment that day. He did try to get here to test. He didn't. He spoke with Mr. Warren Green. Mr. Green told him to turn himself in. He did. He is gainfully employed still at Amazon. He lives with his family. He attends Macomb Community College. Prepared to test either here at Community Corrections or if we can arrange somewhere.
Why didn't he go over and test?
You know, Your Honor, he lives in Macomb, Michigan, and he tried to get over here in time, and it's a long, my understanding of where it is it's kind of north Macomb County. It's a long ride in the best of circumstances right now. I think 696 is torn up. He just didn't get here. So he did turn himself in Tuesday because transportation issues didn't allow him to do it yesterday. So he turned himself in Tuesday because that's when he could get here. But he is prepared to, he does have transportation now. He is prepared to
He
test.
returned from the Bahamas on the 21st. Right?
I believe so, Judge.
So he couldn't get to test 22nd, 23rd. I mean,
That, I think he had some confusion. He has no criminal history. I think he had some confusion about the actual testing procedure. He thought he would, there was a color he was supposed to do. I am prepared to help him negotiate that.
No. Couldn't have had that. Because when I gave him permission to go, specifically, he was to come back and take an ETG. And then he never showed.
Oh, okay. Your Honor, I'd ask the court to excuse that failure and allow him an opportunity to demonstrate to the court that he is a good bet to both appear and to test as required by the court. Like I said,
He's supposed to come back and test. I mean, I let him go. And then he just didn't do it. And it's not, I mean, he came back on the 21st, which is, well, he came back and was supposed to test on the 21st, but he didn't, that would have been a Wednesday. And he said he couldn't get here from Macomb those 3 days.
Yes,
So
Your Honor.
somehow or another, he got himself to the Bahamas, but he can't get from Macomb County to Washington County. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Case, People versus Antoine Coleman.
Assistant Public Defender, Superior Louis, Your Honor, on behalf of Mr. Antoine Coleman, state your name for the record, please.
Antoine Coleman.
Judge, we do have a green form. We're requesting an adjournment in this matter. Last time we were here, we did adjourn to see if we could get Mr. Coleman into the 14B recovery court.
I remember.
Can the court see if we have a copy of the referral? I reached out.
If we have a copy, this is a joint venture. What do you mean? We?
Judge, I just want to know if I needed to submit another referral.
I have a copy of it.
Okay, so 14B states that they have not received anything in regards.
So they weren't part of the we.
It's a collective.
No, I'm not. I'm a lone wolf. Go ahead.
So Judge, we're asking for the adjournment for that purpose and I don't know.
Go ahead.
He just said that they don't have anything on Mr. Coleman in regards to, the referral.
Okay, so somebody might not have gotten a copy of what we have, because I have it signed by Ms. McDuffie myself.
Yes.
From April 17th.
Yes, Judge. That's
all right. Let me then do this. Adjourn probable cause out to the 15th of this month. And then Ms. Eckenroley.
Yes, Your Honor.
Would you like a copy from my file?
That would be amazing, Judge, please.
Would it?
Yes. I'd greatly appreciate it.
I'm not gonna give it to you. She made it part of the. No, we are not giving it.
We are not. Thank you so much, Your Honor.
Bond will continue. Thank you, sir.
Thank you.
Court calls the case, People versus Artist Valentine Lewis.
Andrew Childers appearing on behalf of the people.
Sorry, Your Honor.
Okay.
Sorry about that, Your Honor. Assistant Public Defender Natalie Tate with and on behalf of my client, who stands to my right, Mr. Valentine Lewis. Can you please state your name for the record, sir?
Artist Leroy Valentine Lewis.
Thank you.
Thank you, Your Honor. We're respectfully requesting to set both cases for exam. I believe discovery is complete.
People have their witnesses available at 13.
That is fine, Your Honor.
Preliminary examination in these matters will be set May 13th, 2025, 9 a.m. That is before Judge Valvo in person. Oh, these are old cases, eh? Yes, the forms are old. All right. Thank you. Bond continue.
Thank you, Your Honor.
Case People versus Contrell Cooper.
Assistant Public Defender Jay Bellinger, on behalf of, but not with Mr. Cooper, Your Honor. I have tried to reach out. I've left several voicemails and an email, and I just looked to see what he might be in Wayne County Jail. I am uncertain as to that at this point, but I don't know where he is at that for the time being.
Bellinger, I went through all the whole morning not having to issue a bench warrant.
And Your Honor, Your Honor, just to be clear, you don't have to. It is a decision that's,
It is.
When in doubt, adjourn it out. Am I right?
Is that right?
That's what the saying, that's the old adage, Your Honor.
That's the public defender's motto.
I had a shirt and everything. I brought it to this court.
Bench warrant will issue for defendant's failure to appear.
Come on.
Bond will be set in the amount of 10,000 cash surety. That warrant will issue immediately.
I won't hold it against you.
And I don't care. Court does call the case. People versus Wyona Harvey. This happened really. Oh. Cheers. Hello.
Hello.
What's your name?
Winona Cheryl Lane Harvey.
All right. Ms. Harvey, you're here without an attorney.
I would like a lawyer.
You want counsel to represent you in this matter?
Yes.
Okay, do you know what you're charged with at all?
No.
Okay. How did she? What happened at your arraignment? So nobody's talked to you since your arraignment?
No.
It says, did you refuse the public defender at that time?
I believe so.
Okay, you just may not have understood what it.
Well, he was talking kind of low. The guy that talked to me was talking low. And it happened real quick. He didn't talk to me for a short amount of time.
Okay, all right.
I would like a lawyer.
Okay, let's see if we can fix that. I just want you to know what you're charged with, okay?
And I don't believe the device they found on me was mine because there's a lot of.
Hold on. I don't want you saying anything about the case, okay?
Yes.
All right. You're before the court on a charge that alleges that on May 31st, 2023 at the Huron Valley Correctional Facility, okay?
Mm-hmm.
That you did make an assault on a prison employee. You understand that?
Yes.
Okay. That's a felony punishable by up to 5 years incarceration and a $2,500 fine plus court costs. You understand that?
Yes.
Okay. And my understanding and what I'm hearing from you is you want to be represented by counsel.
Yes.
All right. See, we fixed it. Public defender's case.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Harvey. Your Honor, we'd ask for a brief adjournment if the court would consider 1 week so that we can get discovery and meet with Ms. Harvey and have some conversations regarding this case.
All right, okay, you think 1 week, is she housed with us? Currently, or she is, okay. So here's what I have the 6th or the 15th. Because of judging, so I have 5 days or I've got 14 days.
Take your nap.
Well, Ms. Harvey, what are you held on here on this case?
Same thing. Oh, they said they saw me go in somebody's backyard and assault them as well.
Well, let me ask you this. Is there another case besides this one holding you that you know of?
No, sir. No, sir.
Mm-hmm.
That's that. I believe that's what I was here for. They said assaulting an officer.
Yeah.
Yeah.
Okay, that's what they said you were here for.
Yeah.
1 moment, Judge, we're confirming.
Okay, yeah.
When did you get coming to?
Pardon?
Like.
Yeah, I see that.
A week ago.
Yeah. She has. Okay. Judge, this appears to be the only matter holding her with a $1,000 10% bond. However, does appear she has an MDOC hold.
Got it. Okay. So let me do it this way. I'm going to put it on the 15th.
Okay. 2025
at 9. And I'll have her bond in this case continue. All right. That way they'll be able to take a look at everything for you. And then you can come back and see us. All right.
Okay. So I have to stay here.
You have to stay here right now. There's a bond. There's about $100 bond holding you here, but you have a hold from the Michigan Department of Corrections anyway. So if I were to let that bond go, you're going to go someplace else. You're not going to get out. Okay.
Did you just say, you said if you let the bond go, I'll go someplace else, but I'm not going to get out?
But you wouldn't get out because there's an MDOC hold.
If the judge gave you a personal bond today, Michigan Department of Corrections would come pick you up and then you wouldn't be here anymore. It'd be just more difficult for us to talk with you and meet with you about your case. So right now, this $100 is keeping you here so we can meet with you, we can get the discovery and have some conversations. And then we can try to get a hold of your parole agent. Does that make sense?
Yeah, well, I don't have a way to get in touch with my family so I could get the bond.
Yeah. I'll come talk to you probably tomorrow. I don't want you to post the bond right now. Does that make sense? If you post your bond, you're going to go to the Michigan back to Huron Valley.
Okay.
Most likely.
Okay.
So don't post your bond right now.
Okay.
Don't post your bond until we talk to you.
Okay.
Okay.
Yes.
Okay.
All right. You got it. Thank you, ma'am.
Thank you, Judge.
Court calls the case People versus Sean Cotton.
Elsie Virgil is with and on behalf of Sean Cotton, who should appear via Zoom. Mr. Cotton, if you're present, please state your name.
Sean Cotton, you need to unmute and turn on your camera. And get yourself stationary. State your name.
Sean Cotton.
You're requesting an adjournment.
I am, Your Honor. May we approach?
Yes. He has a hat on. Huh? Why? Record should reflect we had a brief bench conference. Probable cause conference will be adjourned May 29th, 2025, 9 a.m. Bond will continue in this matter.
Thank you, Your Honor.
Thank you. And I'll let you talk to your client in my courtroom. I won't deal with it. Thank you. Court calls the case People versus Jacob Halfacre.
Ready. And good morning, Your Honor. Joseph Paul appearing for on behalf of Mr. Halfacre, who I'm told has refused to join us today. Your Honor, by way of further information.
Collective us.
Yeah, that's true.
Okay.
And Your Honor, from the information that our office has gleaned, we did have MDHHS go and do a review on April the 11th, determine at that time that he was still incompetent but likely to regain competence at some point in time.
Was he getting treatment?
They've also, so they emailed us again this morning and told us that we either need a court order from Your Honor or a signed release so that we can obtain records that the Forensic Center has regarding his competency. So my staff is happy to prepare such an order, Your Honor, and present it to you for signature. If
Any objection for people in terms of that? Prepare the order. How much time do we need on this?
Your Honor, given the nature of these things with the Forensic Center, I leave it to Your Honor's discretion, a couple months.
Why don't we do it this way? This is set for conference. So I'll set this out to, was it July?
Yes.
July 3rd, 2025, 9 a.m. Bond will continue.
Thank you so much, Your Honor.
Thank
Good
you.
to see you again, Judge.
Good seeing. Court does call the case, People versus Elijah Kraft.
And then on behalf of the people, Your Honor.
Assistant Public Defender Natalie Patewick, and on behalf of Mr. Kraft, you should be present via Zoom. Sir, could you please unmute, turn on your camera and state your name for the court?
Elijah Kraft.
Thank you, Your Honor. We're respectfully requesting an adjournment in both matters. I believe the 911 calls will be forthcoming very shortly. I did talk to the people about that and they did request them. So we're requesting an adjournment for that purpose.
And that's correct. I did request it yesterday, so they should be here by the end of the week or early Monday.
Probable cause conference, May 15th, 2025, 9 a.m. Bond continued in these cases. Thank you.
Thank you, Your Honor. Thank you, Mr. Kraft. You're all set for today.
Thank you.
Both case, People versus Curtis Damon.
Good morning, Laura Yagi, Assistant Public Defender, on behalf of Mr. Damon. Your Honor, may I inquire as to whether Mr. Damon is on Zoom?
Damon? No.
Your Honor, I did fill out a green sheet requesting an adjournment. I had been in contact with Mr. Damon previously. Unfortunately, I do believe he's homeless and wasn't able to connect with him on the phone. I know he was trying to get into treatment. I spoke with him about that. So I don't have a specific representation today as to his whereabouts, but I would ask if the court would consider a 1-week adjournment. I wasn't in good contact with his girlfriend, but not him directly.
Bench warrant relation for defendant's failure to appear. Bond will be set in the amount of 10,000 cash. Court calls the case, People versus Aaron Daniels.
And is on behalf of the people.
Morning, Your Honor. The Assistant Public Defender from Mr. Daniels.
I didn't think she was going to do anything. I thought she was going to be an acting ruling type of thing. Aaron Daniels.
Thank you, Your Honor.
All right. You stated your name, right? All right. What are we doing?
Your Honor, we're asking for a very brief adjournment. This is the first PCC, but adjournment would be awesome.
And Your Honor, I did also want from the record, I requested the 911 call yesterday, so it should be here right.
Thank you.
All right. Probable cause conference, May 15th, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Case, People versus Fleming Davis.
Assistant Public Defender Hannah Ambbor.
Say your name for the record.
Fleming Davis, sir. Thank you. Morning.
Your Honor, there is still some outstanding video. We're asking for an adjournment. I know that request has been submitted to retrieve the video, so we should be in receipt of it hopefully soon.
Probable cause conference in this matter will be adjourned May 22nd, 2025, 9 a.m. Bond will continue.
Thank you.
Thank you, Your Honor. You're welcome, sir. Court calls case People versus Jordan Davis.
Ryan Bowling on behalf of Mr. Davis.
Jordan Davis.
Thank you.
Judge, I submitted a green form. We are also in this matter waiting on some video discovery. I've reached out to Ms. McDuffie. She's working on it. Hopefully we'll have it soon. So just asking for an adjournment.
Probable cause conference, May 15th, 2025, 9 a.m. Bond continued.
Thanks, Judge.
Thank you, sir.
Thank you.
Court calls case People versus Harold Dennis.
Stephanie Payne on behalf of Mr. Dennis, appearing to my right. Mr. Dennis, when you are present, please state your name for the record.
Harold Dennis.
Your Honor, we are asking for a 1-week adjournment in this matter. Hopefully, when we come back, we will have a clear.
Probable cause conference will be May 15th, 2025.
Thank you, Your Honor.
9 a.m. Bond continued. Calls case People versus Tequila Evans Guyton.
On behalf of Miss Evan Ryan.
Tequila Evans.
Okay, I want to ask how you got named Tequila.
How does she know?
I just want to ask.
She didn't choose her.
I just
know my dad liked this some girl named Tequila, and my mama, she wasn't letting him name me Tequila, so they just named me Tequila, and that's her favorite alcohol.
Yeah, all right, that's fair enough.
I'm happy you did. Sorry, you're able to give him an answer.
I had to ask the
So
story.
couldn't be named after some other woman. So we went for the alcohol. That's all right. That's fair. I
The middle
just
ground.
thought I'd ask.
Middle ground. Happy to ask as well. Your Honor, we're going to be asking for another very brief adjournment on this case. We're just going to continue plea negotiations with prosecution.
If I had been younger, my kid would have been named like vodka or gin. So I'm going on. Just stop, right? Okay. Probable cause conference will be adjourned May 22nd, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
All right.
Thank you.
You take care, Tequila.
You too.
Tequila, who's that with you?
My great grandma.
Your oh, okay, all right. Because she said I wasn't involved in any of that, right? Okay. Take care. Court calls the case People versus DeJean Gray or DeJean Gray.
That's a lot of people.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Gray, who is not here, Judge.
Oh.
Your Honor, I did submit a green sheet. I did receive a call and an email from the Harbor Oaks facility up in Anchor Bay, I believe. It's a mental facility. Mr. Gray is there. They believe he'll be released.
He is there?
Yes.
Okay.
We were able to confirm that, Judge. I'd ask to adjourn this matter. They believe he'll be there at least another few days, and then they'll find him some transitional IP.
So it'll be there, and then it's gonna be a transitional housing type of circumstance. All right. Why don't I do this? Why don't I adjourn this out to the 29th?
Thank you, Your Honor.
Let him do that and get settled. May 29th, 2025, 9 a.m. I don't have your green sheet.
I'll do another one.
You said May 22nd, Your Honor?
29th.
29th, thank you.
Court calls the case People versus Sarah Gray.
Michael Gann, Assistant Public Defender for for Ms. Gray, Your Honor. I don't have any explanation as to her whereabouts. I'd ask for a show, please.
Gray?
I have called. I have called in the courtroom in the hallway.
Yeah, that's accurate. Bench warrant, bond 10,000. Cash surety. That warrant will issue immediately. Court calls the case of People versus Taiwan Griggs.
People. Stephanie Cannon on behalf of Mr. Briggs, who hopefully is appearing by Zoom, Your Honor. And I will apologize to the court. I tried to do this with stipulation, but I missed the deadline. So my apologies.
What'd you say?
I was trying to do the adjournment by stipulation, but I missed the deadline. So my apologies. I'm just asking for a 3-week adjournment. He has been meeting with our AIM team. Together all the resources necessary presented to the prosecutors. So there's hopefully a better resolution to this case.
Can you state your name?
Taiwan Griggs.
Thank you. All right. Without objection, probable cause conference will be adjourned May 22nd, 2025, 9 a.m.
Thank you so much, Your Honor.
Continue.
Oh, thank you.
Thank you, sir.
Thank you.
Court does call the case of the People versus Candace Huddleston.
Andrew Childers appearing on behalf of the people, Your Honor.
And Assistant Public Defender Jay Bellinger on behalf of Ms. Huddleston, who is present, Your Honor. Ms. Huddleston, can you please state your name for the record?
Candace Huddleston.
Your Honor, at this time, the people would be moving to dismiss this case without prejudice. I'll have a nollie pros filed with the court.
Any objection?
No objection, Your Honor, and I think this balances out the previous bench warrant that you issued on.
No, not really.
Come on.
Case is dismissed.
Thank
Good
you.
luck to you, Ms. Huddleston.
Thank you.
Take care of yourself, okay?
Court calls the case People versus Jennifer Jones.
Mike Gaddy, Assistant Public Defender on behalf of Ms. Jones, Your Honor. Your Honor, we have called out to Ms. Jones. She is not present.
Bench warrant, 10,000, cash surety.
Thank you, Your Honor.
The warrant will issue immediately. Court calls case People versus Lamine Kaba.
Assistant Public Defender Natalie Pate on behalf of Mr. Kaba, who may be present via Zoom. Mr. Kaba, if you are present, can you please unmute, turn on your camera and state your name for the court?
He's not currently in, but my staff indicates he's been dropping in and out. So what I will do, I'll grant your request. And for an adjournment in this matter.
Thank you very much, Your Honor.
It's out to the 22nd. And then maybe he can either appear in person or get stable Wi-Fi.
Absolutely, Your Honor. I believe he has been having some technology issues lately. Thank you, Your Honor.
Thank you. Court does call the case People versus Jeremiah Palmer.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Palmer. Please state your name for the record.
Jeremiah Palmer.
Thank you. The court signed an order, protective order regarding the forensic video, so we're waiting for receipt of that. Could ask for an adjournment.
That's correct. It was just sent over yesterday after.
May 22nd, 2025, 9 a.m. On continue.
Thank you. Thank you.
Thank you. Let's call the case People versus Terrell Green.
He's gonna be filming. I got it.
All right.
Assistant Public Defender, Tanaka Carey, I can really.
Oh, hold it, Bishop.
You said green judge?
Yes.
Very, very tough.
Aha, Terrell
Jackson
Green.
County, they did
Like
not,
3 pages.
Jackson County, they didn't sign in.
Yes, Your Honor. So we'd ask for an adjournment, Judge. Please.
We.
Oh, I would be requesting an adjournment, Your Honor.
Probable cause conference will adjourn May 22nd, 2025, 9 a.m.
Thank you so much,
Don,
Judge.
continue. I do. Let's see how this worked out. Recalls case, People versus Elton Bell. Oh.
Assistant Public Defender Chelsea Regiels, with and on behalf of Elton Bell. Mr. Bell, please state your name.
Elton Robert Bell Jr.
Thank you. Virgil, though, always, if she tells me to pass it and they're on their way, they get here. I don't know what she does. She probably
do my
calls it
best,
maneuver.
I'd like to apologize to the court too, because I know your time is valuable for being late.
You know what? Don't worry about it. And you know, you need to thank the young lady next to you because she had you covered. She told me that you were on your way and you were trying to get down here. So she convinced me to pass it so we could give you time to get here. So no apology needed, sir.
Okay, thank you.
Your Honor, we are asking for an adjournment. Mr. Bell has some restitution to pay in hopes of earning a misdemeanor offer. We would ask for as much time as the court would allow. If we could get a month, he hopes to make substantial progress during that time.
In a month's time? Okay. So let's do this. Put it out to the last day I have in May, May 29th, 2025, 9 a.m. All right? We'll work it that way. All right, thank you. Thank you, sir. Yes, you may.
Charlie, you're in front of the Honorable Judge Simpson out of the 14th District Court, Washington County, State of Michigan, community jurisdiction with 3 matters this morning. Our number is 1423.
Thank you. Good morning. The interpreter is ready.
Thank you. Can you please raise your right hand to be sworn?
Certainly.
Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Spanish and from Spanish into English in a manner now before the court to help you out?
I do.
Thank you.
We're gonna have to take his volume up. Good morning, Charlie. How are you, sir?
I'm doing great. Thank you, Your Honor.
Court does call the case of the people of the state of Michigan versus Fran Ali Lenzon Mendoza.
El gobierno del estado de Michigan hace el llamado del caso en contra de Fran Ali Benzai Mendoza.
Alexander, on behalf of the people.
Can the interpreter get the counsel's name one more time, respectfully?
It's Ali Zenda on behalf of the people.
Thank you. Tenemos a la señorita Alexandra representando la fiscalía.
Assistant Public Defender Chinaza E. Carey Akinruli on behalf of Mr. Mendoza.
Representando al señor Mendoza tenemos a la asistente defensora pública Jinasa Iker.
Mr. Mendoza, can you state your name for the record, please?
Favor de mencionar su nombre para el acto de grabación, señor Mendoza.
Sí, mi nombre es Fran Ali Lorenzo Mendoza.
Sure, my name is Fran Ali Lorenzo Mendoza.
Your Honor, may we please approach?
Pide permiso la señorita abogada defensora pública del demandado para acercarse al estrado.
Court does call the case of the people of the state of Michigan versus Danelle Young. Oh, there
afternoon,
he
Your
is.
Honor.
Good afternoon, sir.
I'm Special Assistant Attorney General Mitchell Wood for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Young, who should be present via Zoom. Sir, can you please unmute, turn on your camera and state your name for the court?
I don't have Young. The individual who is.
Yes.
Your name, sir?
Donnell Young.
All right, that's it. Okay. You got it. Okay.
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. I'm respectfully requesting adjournment. I believe I may have reached out to the wrong Assistant Attorney General regarding this case, and I just wanted to touch base with them prior to next steps. I have discussed this with my client. We're respectfully requesting a very brief adjournment.
No objection from the people.
Judge, no, I'm wondering, so Mr. Young is out of jail. Did he make bond? Did he make a cash bond? I don't know. Judge.
I have his bond set at 3,931 cash. So I'm assuming that was posted.
That is.
Mr. Young, did you post that bond?
Yes.
Okay.
I don't have in my file, Mr. AG, I don't have a receipt or anything, but I do see that that was the bond that was set.
Judge, I don't know whether counsel has spoken with Mr. Young about his intentions, whether he wants to pay that bond over. I know you have an expedited process to do that, and if he wants to do that, it would be great to do it now while we're still in district court.
To pay the bond over? Is that, is Mr. AG, that's what you're asking?
Yes, I'm sorry, Judge. Yeah, yes, I'm asking whether the defendant desires to pay the bond over. I don't know if it was posted in his name, but it's a cash bond. If it's in his name, which it should have been, I'm asking whether counsel knows whether defendant wants to pay that over.
Well, in the condition of his bond is that they set the amount, and then some time ago, the language that's added that if bond is posted, they're immediately to release it to circuit court, and then they list the case number that's part of the complaint. So that should happen. We've had some hiccups trying to make sure that the money gets over, but mostly it's worked. So I don't know that when he posted it, he knows that that's where it's going.
That was my understanding as well, Your Honor, that I did discuss with him.
To circuit court, to the underlying child support case, not to the.
Yes, to the circuit court, and then I just deleted in terms of what I said the case number for this case, but.
Yeah, so we have no objection, Judge, to setting this over.
Okay.
Then, Your Honor. And counsel, the attorney who would usually be assigned to Washtenaw County, Sarah Brenner, I think is just about to get back into action. She's been off on a little extended leave. So I don't know who you sent it to. I could probably reach out to you. What is your last name again?
Pate, P as in Paul, A as in Apple, T as in Tom, E as in egg.
All right, and your first name, I'm sorry.
Natalie.
Okay.
Don't go through.
I will send you an email, Natalie, and we'll get the process going here.
Thank you, sir. Thank you, sir.
Oh, we put her email in the chat, so it should be there, Mr. Woods.
Perfect. Thank you.
Thank you. Thank you very much.
All right. May 22nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Judge. And I assume the
Thank
AG
you.
will once again appear via Zoom, Your Honor.
Yes, sir.
We greatly
Absolutely.
appreciate it, Judge. Thank you. Thank you, Ms. Pate.
All right. Thank you.
Thank you, Mr. Young. You're all set for today.
Court calls the case, People versus Jack Ritchie.
Good afternoon, Your Honor. For the record, Attorney Russ Donaldson, P number 53660, on behalf of Mr. Ritchie. Will you state your name, please? Jack Ritchie.
Thank you. All right. You're requesting an adjournment on this?
Yes, Your Honor. I was just, the court actually just signed the substitution of attorney today. There's some discovery. I believe there's over 150 pages. There's some additional discovery that I'm asking for. Some body worn cameras, some in-car videos. There's an interview, I believe. I would be asking, and my client's already waived the 21 days, Your Honor. I would be asking the court to set this if possible to June 5th. I know it's a little bit extended, but I'm going to be out of the country for between.
People ask for their dates.
This.
This happened?
Yeah.
Okay. No, go ahead.
I'm sorry. I apologize, Your Honor. I'm going to be out of the country celebrating an anniversary with my wife that's been planned for a while from May 22nd to June 1st. I would ask for June 5th. That would give me enough time to be able to gather all the discovery, advise my client in terms of his options relative to moving forward with an exam.
That's a good attorney. To the extent the judge was not going to give him time, he brought his wife in an anniversary. So that's who I'd be disappointed. I know, I see what you were doing.
I'm afraid of my wife, Your Honor. I just want to let you know that.
June 5th, 2025, 9 a.m. Bond will continue.
Your Honor, can I address one issue relative to the bond that I did bring up to the prosecuting attorney?
Yes.
Okay, thank you.
Let's make. All right, the record should reflect we had a brief bench conference and counsel is going to submit to the court a proposed order for the court. The court will then make a decision in terms of.
That is correct, Your Honor. Thank you for allowing us to discuss this matter sidebar. I'll have my office prepare the order. I'll go out and dictate it and I'll have it sent to your clerk if that's okay via email for entry and approval.
Okay, very good.
Thank you, Your Honor.
Thank you. Okay. Court does call the case of the people versus Philip Carson.
Ashalani for the people.
Senator Jones, I'm on behalf of Mr. Carson, who is present. State your name, Philip.
Philip Carson. Thank you.
Your Honor, if you want, I have documentation that I provided to the people about Mr. Carson's journey that I represented the last time from University of Michigan Psychiatric Services to Hillsdale, then back, he did get his GPS tether put right back on as soon as he got released, and he's back engaged with CMH. I provided that to the people. If the court wants it, I can provide it.
I don't think I need to.
Thank you. And then regarding today's PCC, we're asking the matter be set for a preliminary exam.
All right. And discovery is complete.
Yes, Your Honor.
And would the people have their witnesses available the 13th?
We can try.
What's the next available, Your Honor? Could we possibly do the 20th?
I can do the 20th.
Thank you, Your Honor.
Any objection from the people?
Oh, Your Honor.
Preliminary examination in person, May 20th, 2025, 9 a.m. That will be before Judge Perry.
Thank you, Your Honor.
Thank you, Your Honor.
Bond continued. Thank you.
Oh,
Thank you, Your Honor.
Thank you, sir. Let's call the case of people, state of Michigan versus it's WeTech.
WeTech Inc. Your Honor.
Inc. Yes. Okay.
Andrew Childers appearing on behalf of the people, Your Honor.
Your Honor, Joe Simon, on behalf of Mr. Ng. Mr. Ng, will you unmute and state your name?
We take
Okay. All right. Got it.
Mr. Childers?
Your Honor, at this time, people would be moving to dismiss this case without prejudice.
I'm assuming there's no objection.
No objection.
All right. This case is dismissed without prejudice. All right. Thank you. Court calls the case, people versus Alan Payne.
Your Honor, Joe Simon, on behalf of Mr. Payne, making his way to the podium. State your name, Alan. Alan Payne?
Thank you. We're looking for an adjournment.
Yes, Your Honor. I made a proposal to Ms. Londi, who's going to talk it over with her supervisor and come to a decision, we hope, on the next court date.
May 22nd. Will that work?
Fine, Your Honor. Thank you.
Yes.
May 22nd, 2025, 9 a.m. or as your invite indicates, bond will continue.
Go home.
Continuing with the Joe Simon Show, court does call the case. People versus Michael Sandusky.
And then on behalf of the people, Your Honor.
Your Honor, Joe Simon on behalf of Mr. Sandusky. Mr. Sandusky, when you approach the podium, please state your name.
Michael Sandusky.
All right, what are we doing on this one?
Asking for an exam, Your Honor. If we could have that same date, I don't think that other matter will actually go to.
Did he just do that? Did he just do that? He did, didn't he? Oh, yeah, that. I forgot. I'm in his world now. Discovery's complete.
Yes, Your Honor.
And Your Honor, I did want to say I did request the 911 call yesterday, so it should be here.
Okay. All right. Preliminary examination in person will be set May 20th, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
Thank you.
Thank you. And moving on to the next assignment. Court does call the case. People versus Deshaun Tompkins.
That's a lot of people.
Joe Simon on behalf of Mr. Tompkins, go ahead and state your name.
Sean Tompkins.
Thank you.
And Your Honor, in this case, I presented a proposal to Ms. Lundy that she is investigating the things that I represented. And if she, I'll let her tell you how much time she needs for the next day.
Will the 22nd work?
That's fine, Your Honor. Thank you.
Probable cause conference will be adjourned May 22nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you, sir.
Okay.
Is that it for you, Mr. Simon, finally? I mean.
Yes, Your Honor.
Okay.
Thank you, Your Honor.
Sir.
Yes, sir.
Court calls the case of the people versus Angelica Towers.
And then on behalf of the people.
Good afternoon, Your Honor. Edward Drukas on behalf of Angelica Towers.
Angelica Towers.
Thank you.
I'm looking to obtain the discovery in this case. I'd be asking for an adjournment.
Okay, probable cause conference, May 15th, 2025. 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the cases of the people versus Matthew Fitzgerald. Two cases.
Absolutely, for the people of both matters.
Good, Judge. Good afternoon, Your Honor. Robert Ellman on behalf of Mr. Fitzgerald. Torshio Feaster, Assistant Public Defender, also on behalf of Mr. Fitzgerald, on file number ending 507. Your Honor, Mr. Fitzgerald is not here. However, there's a good reason for that.
Oh.
And I'd love to share that with you.
Okay, go ahead.
So Mr. Fitzgerald has a case in Livonia. And as you recall, due to a bond violation, you placed him in custody. During that time while he was in custody, yeah, I'm just trying to make the record clear.
You sounded accusatory, but go.
No. I'm not accusing you of anything.
No, I got thick skin. Go ahead, Mr.
Well, while he was in custody, he was scheduled for his sentencing in Livonia, which he then missed. So they issued a warrant. He turned himself in on that warrant, and they did immediate sentencing, and he is currently in custody because they sentenced him to 10 days in jail. So that is why he is not here.
So, did you hear Elman's whole story? So Elman's whole story is, Judge, you tipped the first domino.
No, Your Honor.
It started this whole thing on that. Yes, that's exactly what you were saying. That's why Feaster is standing awake.
Well, Your Honor, he is in custody,
Feaster
and so therefore he's not here.
Podium. Feaster like looking at you like, go ahead, you say it, man.
Have I mentioned how good it is to see you again, Your Honor?
Probably should have led with that. All right. So you're seeking an adjournment.
If the court would be so kind.
Well, Mr. Fisher, are you seeking an adjournment?
Yes, please.
Then that I'll grant. All right. Probable cause conference on both of these cases, May 22nd, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Thank you, Your Honor. 22nd.
Mr. Smart, he just said, I am not kidding. Court calls the case, People versus William Phillips.
And is it on behalf of the people?
Good afternoon again, Your Honor.
Oh, no, he's back.
Again, always great to see you. Robert Ellman with and on behalf of Mr. Phillips. Mr. Phillips, can you please state your name for the record?
William Phillips.
Mr. Phillips is like, I'm not with him. No, go ahead. All right, what are we doing?
Your Honor, I was just appointed on this matter. I would be asking for an adjournment for time to get discovery. However, I'd also like to address bond whenever you would like to hear that from me.
Like to hear that. I'll adjourn this to May 22nd, 2025, 9 a.m. Yes, that's the bond, Mr. Earl.
Thank you, Your Honor. I would be requesting a change in the bond order to a no non-consensual contact. It's my understanding that the complaining witness in this matter has shared that request with the victim's advocate's office. And again, as you know, that would put the ball in her court as to whether to have contact with Mr. Phillips or not. So that's what we'd be requesting.
Okay.
I would also state that when did she do?
June 8th.
She's pregnant and due June 8th, and they do, how many other kids? Two?
Two.
They have two other children at home, so.
Your Honor, at this point, I would object. She did mention that to our victim advocate, and that was not, however, I just have concerns given the facts in this case and that strangulation. I think it's something that should be addressed at exam, or potentially in the future, but I don't believe it's appropriate to change that, provision at this point.
And if I could just add, Your Honor, this is, an older case, so they've been, to my knowledge, prior to the charges being filed, successfully cohabitating since the date of offense without any issues.
All right. I am disinclined to change that. I typically want to hear myself from anyone wishing to change the bond, even though they may communicate it. I then want to hear the people's sort of feelings on that, but I would need to hear from the individual themselves.
Thank you, Your Honor.
All right, so motion for bond reduction at this time is denied.
Thank you, Your Honor.
Thank you.
All right, you're all set.
Thanks. And that's it for me, Your Honor. You don't have to deal with me anymore today.
Okay, so apparently on my face, it looked like I cared. No, okay. I'm sorry. I'm sorry. That was so wrong, Mr. Ellman. Thank you, Mr. Ellman. Always a pleasure, sir. I know that was. I feel bad now. What? Take it back. Court calls the case, People State of Michigan versus Michael Williams.
People.
You're standing against the wall.
Yep.
Oh, was it? Take care, Mr. Ellman.
You too, Your Honor.
Something, Your Honor?
Pardon?
Figured I could get away with it a little bit.
Just a little bit. It said pick on me today.
Oh, no, that wasn't.
Go ahead.
I
called it.
Oh, thank you, Your Honor. Good morning, or good afternoon, maybe, please, honorable court. David Burgess on behalf of Mike, what? Williams, William or Williams? Williams. Okay, they said William in the thing, Mr. Williams, Your Honor.
You guys are close, I think.
Yes.
All right.
Judge, I'll get on the record, but I just got this case yesterday, so.
Okay, very good. So you're looking, I need a green sheet, but you're looking to.
I'll fill one out, Your Honor, but I'm looking for an adjournment, and the next available date I have is the 22nd of May, if that's okay with the court. I know it's a little farther out, but.
So who said, is there a sign on the door that says, go and pick your own date?
It's on the other courtroom.
Oh, is that what it was?
Yeah,
You thought it was here.
I'm sorry, I must have read the wrong door. so.
Yeah, you must have. May 22nd, 2025, 9 a.m. Bond in this matter will continue.
Thank you very much. Appreciate that. I'll fill out a sheet. I'll meet you. Okay.
Court calls the case, People versus Jalen Kendrick.
Alexander, on behalf of the people, your honors. Senator Kevin, others on behalf of Mr. Kendrick.
All right, what are we doing?
Your Honor, we are going to be setting this matter for preliminary examination.
All discovery is complete.
We have all video discovery and all paper discovery. There is a 911 call, but we don't believe that that is essential, and we don't need that to continue with preliminary examination.
All right. So there will not be an adjournment for that purpose. Would the people have their witnesses available on the 13th?
We'll do our best.
Preliminary examination, May 13th, 2025, 9 a.m. That is before me. Bond will continue.
Thank you, Your Honor.
All right, thank you. Court does call the case, People versus Anishika King.
Rachel McDuffie for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. King, who's approaching now. Ms. King, can you sit into the record?
Anishka King.
Your Honor, there is some video discovery that we are waiting to receive. We're asking for an adjournment for that purpose.
Matters adjourned May 15th, 2025, 9 a.m. Bond in this matter will continue.
Your Honor, if I may briefly address. Your Honor, I brought to the court's attention last time, and I believe the people didn't take a position regarding Ms. King is asking the court to consider being placed on a sober link rather than a scram tether due to some medical issues that she has. The court, we were informed when we were here by Ms. McDuffie that she had an outstanding warrant in the 36th district, and the court said that they would consider it if she was able to have that warrant recalled. She has been in the process of taking care of her matters in 36th district. It appears that she's set for court on the 6th and the 7th of next week for arraignments.
On the 36th district court.
Yes, but I will be clear to the court, the paperwork I have doesn't appear to be the one that Ms. McDuffie brought to my attention, but it's before the same judge, Judge Kennedy. And so I'm hopeful that when she appears on that, they can handle the other matter. I just don't have paperwork of the one that she was hoping to get resolved. I don't have confirmation of that matter, but she is set next week for 2 different arraignments.
And you're just looking for a sober link as opposed to
the scram. But she is attempting to attend to all the matters and make sure that she complies with all bond conditions. And my understanding, she has not had any issues regarding bond at this point.
Any position from the people?
Your Honor, no, I know that the court's concern was the fact that that case was a high BAC matter. So I did provide Ms. Apple, I think she can share with her client the actual ROA from that case, unless she can call with the exact case number. I will be able to verify it as soon as it happens, because I can look it up and see that has changed. So I'll leave it again to the court.
All right. But she went down there to take care of matters at 36. It's clear.
It's clear that she has made progress, yes, and is set for 2 different arraignments next week. And I will give her the ROI to take with her with the new date when she goes on Tuesday or Wednesday, the 7th, to make sure that that also gets resolved if that is missing in some way.
Okay, well, she's headed in the right direction. I'm going to grant the motion for the change. I'll allow defendant to be switched to a sober link.
Thank you.
Price but it's 3 blows per day.
Okay.
All right.
Thank you.
Thank you.
Hang tight for me because I'm going to print that paperwork for you. Thank you.
Court calls the case, People versus Latrice Lee.
National Money for the people.
Afternoon, Judge Mike Gaddy, Assistant Public Defender on behalf of Ms. Lee, who's approaching. Excuse me. Your Honor, may we approach briefly?
Sure.
Thank you.
I mean, yes.
Your Honor. Your Honor, there are some Secretary of State issues that I would like to further advise Ms. Lee on, because I think they are somewhat based on where her license was after this and where it might go with this arrangement. It's fairly complicated. I want to make sure she understands exactly what at least I believe is going to happen with her license.
All right.
Thank you.
And again, record should reflect we had a bench conference. I'll adjourn the probable cause conference to May 15th, 2025 at 9.
Thank you, Your Honor.
Thank you. Thank you, ma'am.
Can you come to my office?
Court does call the case, People versus Michael Lee.
Mike Gaddy, Assistant Public Defender. Okay. Yeah, 2 days from now, okay?
Okay.
Your Honor, I have had no contact with Mr. Lee. I've called him, called in the hallway, called in the court. I don't have any explanation as to his whereabouts. I'd ask the court for a show cause in this matter. But
bench warrant will issue on 10,000 cash surety.
Thank you, Judge.
That warrant will issue. Does call the case, People versus Chad Major.
Andrew Childers appearing on behalf of the people.
Second, on behalf of Mr. Major, it's.
Aye.
Apologies, Your Honor. Mr. Major, when you were at the lectern, please state your name for the court.
Chad Major.
All right.
Your Honor, we are asking for a preliminary exam to be set,
All right. Discovery is complete.
to the best of my knowledge.
People would have their witnesses available on the 13th.
Your Honor, would it be possible to go 1 week past that?
Any objection from defense?
No objection, Your Honor.
Preliminary examination in person, May 20th, 2025, 9 a.m. That is before Judge Perry.
So it'll be here at 9 a.m. in front of.
Bond will continue. Thank you.
Thank you so much, Your Honor.
Thank you. Court calls case, People versus Makisha, is it Melchor?
Melcher, Your Honor.
Melcher.
Andrew Childers appearing on behalf of the people.
And Assistant Public Defender Jay Bellinger, on behalf of but not with Ms. Melcher, Your Honor. Informed me this morning that she was checking into the inpatient facility. I anticipate that within the next 4 hours, my office will have the facts from that. She has let me know that she is in the process of the entry at the moment. And I understand, Your Honor, that
what facility?
She's in an inpatient facility off of West Grand or East Grand Boulevard in Detroit. That's all I know at this time, Your Honor. I understand that we've adjourned this matter a couple of times so that she could get in. She had some problems doing so. As I stated, I anticipate some facts coming into our office that I can send to the court later on today as soon as I get them.
Well, here's what I'll do. I'll issue a bench warrant for a failure to appear, bond 10,000, cash surety. I will not issue that warrant until the 5th.
Thank you, Your Honor.
Court calls case, People versus Jody Merritt.
People, or Yagi, Assistant Public Defender, apologies, with and on behalf of Ms. Merritt. Your Honor, may we approach in this matter?
Pardon?
May we approach in this matter?
Yes, you may.
Non-consumption, consumption. The people said non-consumption. It detected alcohol, but it was non-consumption. It was one of the things.
Go ahead.
Your Honor, I know I made arguments at the bench regarding my client's medical issues and her all of the things she's done to stay sober. Specifically within the last couple of weeks, she's gone to AA meetings almost every day. She keeps a log. She has verified signatures. She set up an appointment for intensive outpatient. She, I know I said this at the bench, but just to reiterate for my client's benefit, she called down firms. They told her she was not eligible for inpatient. She has medical issues, which I won't go into detail on the record, but I did at the bench. And we were asking the court to consider continuing her bond prior to the bond violation hearing, which we are requesting at this. We would request that it be set for a bond violation hearing.
And Your Honor, as I indicated at the bench, previously we had extended an offer in this case. That offer at this time is revoked. The defendant does not have a current plea offer. It may be made again at a later time, but right now it has been revoked. The offer in WI second is the sobriety or recovery court. The issue here is that the scram tether does seem to confirm a 21-hour long tamper with alcohol detected. So people have concerns for the general safety of the public, as this defendant is currently on bond for a operating while intoxicated third offense with an alleged BAC of 0.17. I think it's 171 on the blood draw. And the risk that comes to the public, if this is a person that is on the most restrictive bond condition we can impose for alcohol, other than incarceration, who has an alleged tamper with that scram, there's too much to ignore, and I am requesting the defendant be remanded at this time.
Court, having listened to argument and having examined the alleged bond violation in this case, does find that it's significant with reference to the tamper to the device with alcohol detected. And for those reasons, and the court, on seeing it initially, issued a bench warrant with no bond. At this time, the defendant's bond, the court is going to order the defendant's bond is revoked. And I will set a bond violation hearing as well as her PCC for May 15, 2025 at 3 p.m. Defendant is remanded. Court calls the case People versus Jacob Miller.
Assistant Public Defender Jay Bellinger on behalf of Mr. Miller who approaches. And Mr. Miller, can you please state your name for the record?
Jacob Miller.
And Your Honor, I have submitted a finding and order on the competency to the court this time, asking for signature on that.
All right. Is there any other evidence regarding competency to submit to the court?
And nothing from the defense.
The court, upon reviewing the report, would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent, and I have signed the order.
Thank you, Your Honor.
And you're requesting an adjournment. PCC.
We are, Your Honor. I'm requesting 3 weeks from the court so that I can work on a resolution.
All right. And what I will do is I will, hold on. I'll set a probable cause conference for May 22nd, 2025. 9 a.m. or as your invite indicates, bond at this time will continue.
Thank you, Your Honor.
Thank you, sir.
Is this for you?
Court does call the case on people. Antoine Patterson.
Take care. Assistant Public Defender Jay Bellinger on behalf of Mr. Patterson who approaches, Your Honor.
Antoine Patterson Senior. Thank you. You're requesting an adjournment in this case?
Yes, Your Honor.
Any objection from the people?
I'd like to address bond
And if we may approach for that.
May 22nd, 2025, 9 a.m. Mayor Pro Tem. Very true. Looks like we had a bench conference in this case, and it mainly revolves around the no contact provision. My understanding, the current no contact provision with Morgan indicates as allowed, except as allowed by CPS. I will be deleting that except provision, except as allowed by CPS. My understanding, no objection at this time for the defense.
That is correct, Your Honor.
Make that change, basically granting that exception to the motion. All right, and we return to the 22nd.
Thank you, Your Honor.
And we'll continue. All right.
This is for you, okay?
Oh, thank you, sir. Thank you. All right, take care. Court does call the case people versus Taiwan. Hey,
Not with Mr. Phelan.
that's because he's on Zoom.
I tried to reach him. Okay. I need to update contact.
Phelan, can you state your name?
Taiwan Phelan.
Your Honor, we are,
Okay, yes, go ahead.
we're gonna be asking for an adjournment. I don't have contact information for Mr. Phelan, or I do, but it's disconnected.
All right.
Am I able to get his contact information on the record?
Does
that work?
Put it on the record.
Okay. Mr. Phelan, can you call the public defender's office so we can talk to you and have contact?
Actually, yes, call the public defender's office. He's at 14-2.
Okay.
All right, I'll adjourn this probable cause conference, May 22nd, 2025, 9 a.m. or as your invite indicates, bond continue. Thank you.
I'll talk to you, Mr. Phelan.
Okay.
Court does call the case people versus Tremaine Pinder.
How about Mr. Pinder?
Tremaine Pinder. Thank you.
Your Honor, we're gonna be asking for a very short adjournment. We believe there is more discovery and we have investigators working on it.
May 15th, 2025, 9 a.m. Or as your invite indicates, bond continue.
Thank you, Your Honor.
Thank you. Court calls case people versus Joanna Reed.
Assistant Public Defender Jay Bellinger on behalf of Ms. Reed.
Your name?
Ms. Reed.
Johanna Reed.
Thank you.
And Your Honor, I don't know that I submitted a green sheet to the court, so I apologize. I just made first contact with Ms. Reed. She was on a mental health petition, so she was previously hospitalized. So I'm just asking for 3 weeks so that we can discuss her case.
Without objection, May 22nd, 2025, 9 a.m. Bond continues. Thank you.
Thank you.
Court calls case people versus Deborah, Spears.
First, we get from people.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Spears, who should be appearing via Zoom, Judge.
Hello, this is Deborah.
Do you have your camera, Ms. Spears?
It's phone.
No, I can't download Zoom on my phone for some reason because I owe Apple Network. And I can't figure out how to pay it.
Okay. So, Ms. Spears,
Yes.
you're requesting an adjournment.
Yes, Judge.
I'll adjourn your matter out May 22nd, 2025, 9 a.m. All right?
Alrighty, thank you so much. And I will make sure to have Zoom downloaded by then as well.
All right,
Okay.
very good. Thank you.
Thank you.
Thank you.
Court calls the case People versus Carl Tesson.
Brian Mulligan, Mr. Tesson is approaching, Your Honor. State your name for the record, please. Carl Tesson. Judge, I'm asking for an adjournment. This is another matter where I need to obtain some video discovery to review with Mr. Tesson.
May 22nd, 2025, 9 a.m. as your invite indicates, bond continues.
Thank you, Your Honor.
Thank you. Court calls the case People versus Stephen Watson.
And is it on behalf of the people, Your Honor?
Mike Gaddy, Assistant Public Defender on behalf of Mr. Watson, Your Honor. Mr. Watson, state your name for the record.
Stephen Watson.
Go ahead.
Your Honor, I have had a chance to go over this matter with Mr. Watson. We're asking the court to set a preliminary examination.
All right, I will set a preliminary examination, but he has a bond violation in court.
Yes, we're aware of that, Judge.
All right.
Your Honor, I did receive the report and have gone over it.
Does he have a prescription for that?
Your Honor, he did send I believe he tested positive last week. He did pay to have that sample sent to the for confirmation or not. They're waiting on that. Today is his day to test. Mr. Watson has indicated that he will that it will be negative.
For what?
Everything except for, I believe he has a medical marijuana card, Judge. I'd ask the court to allow him to run over there and pass this matter. And
yeah, I haven't, since the end of March, I had cocaine, amphetamines, THC. Amphetamines, THC, and then we went, that was on the 10th, and then on the 14th, I have cocaine again. I have amphetamines then and THC into his system, but he's not reporting any medication that's gonna go as an amphetamine.
Your Honor.
Yes.
I'm also concerned that he missed intake on 4/28 as well.
Yes, I've been working 12 hours, 7 days a week. The community corrections lady told me to come to court, see if you allow me to come and drop. That way they can reassess me and get me back in. But if I drop today, I drop completely clean, everything. And, you know, I'm trying not to lose my job. I've been at the same job for 1.5 years. I've been staying out the way. I can go drop, come back, and everything will come back clean, Your Honor.
Yeah, he is working at Marsh Plating.
Is he saying that, I mean, does he want a hearing on this? I mean, I don't know what else.
Yes, because I'm trying to stay out of jail, trying to keep.
I know you're trying, well, everybody is, but
I just want to be able to go drop, come back, so I can be able to maintain my job and get reassessed. The lady at community corrections said I can get reassessed into a program, outpatient program, if need be.
why is the amphetamine showing up in your system?
That part, I'm not sure. It could have been from some over-the-counter meds or anything, but I haven't used. I've been working every day. Like, that's all I do is work from 3 in the afternoon to 3 in the morning. I'm on my hours. I just asked the court to allow me to go drop to prove that.
You have all of the discovery, mister.
We do have the discovery, yes.
People have their witnesses available the 13th.
We'll do our best, Your Honor.
So is he not admitting to this violation, but
Your Honor, in terms of the amphetamines, he is not admitting to them. In terms of the cocaine, I believe the initial test was positive for cocaine. There was a subsequent one. He did not have the funds. He was not working to the extent that he is now. He didn't have the funds to test it. I don't know if he wants to, you want to hear him?
no, that's okay. Well, I'll just we'll set his preliminary examination in person, May 13th, 2025, 9 a.m. That's before me.
If I could elaborate on bond, Judge.
Sure.
Your Honor, he is not a flight risk. He lives, he's residing over on East Forest, which is, probably 2 miles from here, in Ipsy. I don't think there's been any, we're here on a violation, but there hasn't been any violation alleged contact wise or anything like that. He is gainfully employed. I'd ask the court to allow him an opportunity to test. He has indicated to me that they would, if the court would allow, they would welcome him in for another chance to interview for the community corrections outpatient program.
But if I did drop today, I would drop clean no amphetamines, no nothing.
I'll set a bond violation hearing at that same time. At the time of the preliminary examination, March 13, 2025, 9 a.m. This point in time. Court does call the case of People versus Kyle Beckerman.
Great, Your Honor. Good afternoon, Your Honor. May it please this honorable court. David Burgess on behalf of the not available Mr. Beckerman. Your Honor, the last information I had, he called my office and said he was in Havenwick. I asked him to provide documentation. To date, I have not received anything.
Bench warrant will issue for defendant's failure to appear. Bond 10,000. Cash surety. That warrant will issue immediately. The case People versus Larry Lee.
Good afternoon again, Your Honor. May it please this honorable court. David Burgess on behalf of Mr. Lee, who's appearing on Zoom. So,
okay, I was going to say, did you not have another client?
No.
Mr. Lee, can you unmute and state your name, please?
Larry Lee.
Got him. Okay.
Your Honor, discovery is complete in this matter. We are requesting an exam.
People have their witnesses available on the 13th?
Yes, sir.
Preliminary examination in person will be May 13th, 2025, 9 a.m. before me.
Thank you very much, Your Honor.
Thank you. Bound continue. Court calls case People versus Jamie Foxx.
Absolutely, the people, both matters.
Oh, Jamie Foxx, Your Honor, along with Mike Getty.
Afternoon, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of on case 25 F2 223.
Your name?
Jamie Foxx.
All right, thank you. What are we doing?
One of these cases does involve quite extensive medical records. APA evidence is going through and redacting those, so we disclose to the defense that process is ongoing and not complete, so we do need an adjournment on that case, Mr. Gaddy's matter.
Yes, Your Honor. And I believe we submitted green sheets on both matters. I think it did prior for judicial autonomy to keep both together.
We agree.
All right. What's the timing
There's quite a bit, Your Honor, and there's some other issues, collateral issues going on that the people in the defense need to explore. Perhaps the end of this month.
you guys would agree with that?
I would.
That's fine.
Probable cause conference on May 29th, 2025, 9 a.m. or as your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, ma'am.
For the record, clean on the testing.
What?
Clean on the testing.
Clean on the test. All right.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Candace Holmes.
For the people.
Good afternoon, I'm Rob Jacob on behalf of Ms. Holmes. Judge, can we set this matter for exam, please?
Discovery is complete.
Yes, Your Honor.
Have witnesses available on the 15th. Preliminary examination in person, May 13th, 2025.
Judge, may I address an issue?
9 a.m. before Judge Valvo. Yes.
My client has been ordered to wear a tether. There have been no violations. I don't believe there would be if the court did allow her to take that off. She works in home health care. She cannot work there while the tether is on her. She's asking if the court would please consider removing the tether. She agrees to have no contact with any of the alleged victims, and she will appear for all future court hearings.
Any response from the people?
Your Honor, I know that the victim in this matter would like for my conditions to remain the same. I believe that she did speak and receive an ex parte PPO after this incident. I don't know whether or not it's been served. However, this is a somewhat delayed report. Apparently, the allegations are an argument leading to defendant allegedly swinging on the victim and then pointing a gun at herself and her son, as she was holding at the time. The problem here, the reason this is a delayed report is because she originally claimed this was a family member and did not want to pursue it, but then was receiving harassment and text threats several times a day, every day in the following months after this. I think the hot zone tether is in place for fear that there are several allegations in here of Ms. Holmes carrying firearms despite her prior convictions of CCW and firearms in possession of a felon. Even after that point, she's apparently known to have weapons. Given all of that, I believe that the people, I know that the victim objected because that bond remained.
Judge, just very briefly, my client denies the allegations of having a gun pointed at her, using a gun. This all incident happened over the funeral of her father. People were not invited, and so there were bruised feelings. And it's a family issue. Again, I'm asking if the court would please consider removing the tether. She will have no contact with any other family members.
Motion for bond reduction tonight. I'll leave it in place. Let Judge Valvo decide. Thank you. Calls case versus Takashi Pfeiffer.
Yes,
ma'am. Please, Madam Court, Brandon Byrd on behalf of the Kajay Pfeiffer. Mr. Pfeiffer, can you please state your full name for the record?
Judge Pfeiffer. All right, what are we doing?
Respectfully, Your Honor, we just requesting an adjournment in this matter. So I just got an offer from the people. I'd like to discuss that a little bit further with my client.
Probable cause conference, May 15th, 2025, 9 a.m.
Thank you, Your Honor.
Right indicates bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Deborah Gilmore.
Deborah Gilmore.
Pardon?
The name one more time.
Deborah Gilmore.
And is it on behalf of the people, Your Honor?
Yes, Your Honor. Brandon Byrd on behalf of Deborah Gilmore.
Your name?
Deborah Gilmore.
We figured. All right. What are we doing?
We'd like to set this matter for exam, Your Honor.
Discovery is complete.
As far as I'm aware.
All right. People have their witnesses available on the 13th.
Your Honor.
Preliminary examination will be set in person, May 13th, 2025, 9 a.m. before. That's before me. We'll see you on the 13th.
Thank you.
All right.
Great day.
You too. Court calls the case, People versus William Doster.
And good afternoon, Your Honor. Dan Guerin on behalf of Mr. Doster. Bill, can you unmute and identify yourself?
Unmuted.
State your name, please.
William Doster.
Okay, what are we doing?
Your Honor, as to the competency report, we will stipulate to its findings.
Do these in the same format. I just want to make sure this is what I read.
It's okay.
All right. Any other additional evidence from the people regarding competency? Based upon the review of the competence report, the court would find that the defendant is competent to stand trial, specifically that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, he's deemed competent. I will need an order to that effect, please. All right. All right, what are we doing now?
I spoke to Ms. Reiser today. She's asking, and as am I, for another probable cause conference if the 22nd is available. That's when she said she would be most available.
So it's not you.
It's not me. I'm here when you tell me to be here.
Probable cause conference will be set for May 22nd, 2025, 9 a.m. or as your invite indicates. Bond will continue. Thank you.
Thank you.
Calls the case, people versus Austin Norton.
Good afternoon, Your Honor. Dan Guerin, on behalf of Austin Norton. Mr. Norton, can you unmute and identify yourself? And take your hat off?
Austin Norton.
All right. Okay, what are we doing?
Your Honor, discovery is complete. We're asking for an exam date, please.
All right. People have their witnesses available the 13th.
We'll do our best, Your Honor.
Preliminary examination in person, May 13th, 2025, 9 a.m. That is before Judge Valvo. Bond continued.
Thank you, Your Honor.
Thank you. Case of the people versus Andrew Jason Prater.
Please the court, Your Honor. George Lyons appearing vis-a-vis Zoom. Mr. Prater is to my left, to the court's right.
All right, thank you. All right, what are we doing on this?
Go ahead, counsel.
No, please.
I was just getting ready to say I wasn't sure what you wanted to do with the case, so go ahead.
Like I know it's 30 years old. There's no restitution. I have no idea. I was hoping that you guys just said, Mr. Lyons, go home. But you tell me, counsel.
Oh, this is awkward.
All right. I couldn't quite make out the last part of what he said. I know he said he wanted to go home.
No, what he said is, well, I'm not gonna.
I was hoping that you would tell me, just go home, Mr. Lyons. This is over.
Okay. Counsel, did you want to set it for exam? Set an exam day.
I assume. Are you witnesses still alive?
That is a question I have for one of them, but there are multiple. So I haven't finished trying to research it. I'm not 100%.
Did you want me to put this over so you guys can like have a conversation about this? Other than set it for exam?
That's fine too, Your Honor.
Where I don't have to be involved?
I'm doubtful. I'm doubtful that we will be able to proceed. I just haven't confirmed that. So I'll just say that much.
Okay, so let's give her some time to try to figure that out, counsel. So I'll adjourn this May 22nd, 2025, 9 a.m. or as your invite indicates. Bond will continue. Okay, that'll work for you, Mr. Lyons?
Your Honor, I appreciate that. You guys have a blessed day.
All right, go home, Mr. Lyons.
I'm going home.
Take care. Court calls the case, People versus Kane Kellenberger.
Your Honor, Sam Bernstein with Elberg, who's on Zoom.
Kane Kellenberger.
And state your name, sir, please.
Kane Kellenberger.
All right, got it. All right.
Judge, we are likewise hoping that I can be told we can just go home and that the case is over.
Yes.
But given that probably will not happen, we are going to be waiving the preliminary examination, going to circuit court.
All right. Is that correct, sir? You're waiving your right to preliminary examination?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand that you'll not have that proceeding and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 and 2 with 3 following.
Your Honor, please waive any further reading. Ask the court to continue the not guilty plea and please give us a circuit court pretrial date.
Defendant having waived formal reading, pleading not guilty, court will enter that plea as to all 3 charges. Pretrial will be set for
June 26th at 1:30 p.m. with Judge Lynn.
You said 26.
Yes, sir.
June 26, 2025, 1:30, Judge Slay.
Thank you, Your Honor.
Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court calls the case, People versus Darian Cotton.
Ashley Law for the people.
Your Honor, Sam Bernstein standing in for the attorney of record, Brandon Kizzy, with and on behalf of Mr. Cotton.
And then Darian Cotton.
Thank you.
My bad.
Your Honor, asking the court for an adjournment to so that he can work with the resolution.
Probable cause conference, May 15th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Dejan Williams Watkins.
Richard McDuffie for the people.
Good afternoon, Your Honor. Edward Taylor, P571166, appearing on behalf of Deshaun Williams Watkins. State your name for the record, please.
Dejan Williams Watkins.
All right, thank you.
Your Honor, we need a brief adjournment. He's supposed to be assigned a criminal responsibility, and at this time, he hadn't been tested, so like about. He hadn't been tested, Your Honor, so we'd like a brief adjournment where I could get that information.
May 22nd, 2025, 9 a.m. Bond continued.
All right, thank you. Could we have more time, Your Honor? Because they got to do it and get the report back to me at like 30 days.
Is it 29th?
What day, Your Honor?
I said May 29th.
May 29th. Okay, that's good. All right, thank you.
Bond continued. Thank you.
Thank you.
Should be nicer to. Court calls the case, People versus Kendall Warford.
For those two people.
Good afternoon, Your Honor. Attorney Ron McCoy on behalf of Ms. Walford. Ms. Walford, unmute yourself and tell the judge your name.
Kendall Walker.
Thank you.
Your Honor, I've advised my client of a right to have a preliminary examination. At this point, we're going to waive such right and ask the matter to be bound over to circuit court.
All right, ma'am, is that correct?
Yes.
And you understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 following. Counsel, as to the circuit court arraignment, you acknowledge
We would
receipt
wait.
of the information.
We acknowledge receipt, Your Honor, would waive such arraignment and just ask that it be set for a pretrial date.
Defendant having waived formal reading, your client is standing mute at this time, correct?
That is correct, Your Honor.
Standing mute, court will enter a not guilty plea. Pretrial will be set for
June 24th at 1:30 p.m. with Judge Combs.
June 24th, 2025, 1:30 before Judge Combs.
Judge Conley. All right. Thank you, Your Honor.
Thank you. Bond continued. Court calls the case, People versus James Belleville.
And then on behalf of the people, Your Honor,
Edward Drucas on behalf of James Belleville, but not with, put some reasons in that green form.
Got it. Without objection, I'll adjourn this matter to June 5th. (2025) 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you. Calls case People versus Clifford Gordon.
Edward Drucas for Clifford Gordon.
Sorry.
Clifford Gordon.
Thank you, sir.
We are still negotiating and I'm asking for an adjourned date.
May 22nd.
Thank you.
2025, 9 a.m. Bond continue. Thank you, Mr. Gordon. Court calls case of the People versus Sierra McCoy Nobles.
Edward Drucas for McCoy Nobles. Your Honor, at this time, we are asking for a preliminary examination date.
Sorry, preliminary.
Preliminary, yeah.
All discovery is complete.
To my knowledge.
People had their witnesses available on the 13th. Preliminary examination in person, May 13th, 2025, 9 a.m. That is before judge, before me. Bond continue.
Thank you, Your Honor.
Thank you. Bye. just started leaving. Court calls case People versus Chloe Whitsett.
Ashley Lonnie for the people.
Afternoon, Your Honor. Kia Hickman for Ms. Chloe Whitsett. Ms. Whitsett, please state your name for the record.
Chloe Whitsett.
How are you, Miss Whitsett?
I am blessed and grateful, Your Honor. Thank you. How are you, sir?
I am the same. Thank you.
Amen.
All right. What are we doing today?
Yes, Your Honor. So we were able to, we were able to get the documentation over to 36th District Court. I was able to get the signatures from yourself and all the other judges there. We sent it to Wade Wright and his team, and they are taking care of the signatures at 36. Ms. Whitsett, did they interview you yet?
No, I have not. I've been waiting for the email or the phone call.
Okay.
So, Your Honor, that is what we're waiting on. I did email them and ask for an update. I have not gotten a response. However, they are very responsive because of all of the parties that we were able to get involved.
Okay. Did counsel, I wonder if counsel yelled at him. That's how, like, I respond. All right.
Judge, I don't even know.
What? I'm just saying.
I don't even know how to yell. I promise. My voice just projects a little bit.
Okay, I see. That's how they work. All right. So if I give it if I put it out to the 29th, you think we'll have an answer or we'll have it before then?
That's my prayer, Your Honor. I know everybody's ready for this to be wrapped up.
Yeah, no, I know. And I appreciate everybody working so hard trying to get through this.
And Your Honor, as we're still in this process, I did want to note there is a restitution issue in this case, so that will be something that needs to get sorted out before we're able to ultimately resolve it. The amount of restitution being $674. Just wanted to have that on the record.
Yes, Your Honor. The other prosecutor did let me know that he would like to get the restitution resolved before it's officially transferred. To
yes.
Right.
Can I make it in payment?
Well, let's see, because what's going to happen is once the case does that, she's going to need to take a plea here, right?
Sure. I think Mr. Childers' goal today was just to make sure that we don't lose that in the shuffle and to have a plan for the restitution before the case leaves our jurisdiction.
I think.
Got
I'm
it.
not sure ultimately how we will resolve, but I just wanted to put that in everyone's mind as we're getting closer to the end.
Right, and I think the thing that you have to realize is because from what I understand, there'll be the initial sentencing, and that's where restitution is gonna be assessed. And then it will be transferred over,
I
so,
think so too.
all right. Well, I'll let you guys work that out. During the probable cause conference, sooner or later, Ms. Woodsett, we'll get there, right?
Yes, sir. We're praying for it.
Yes.
We're closer.
May 29th, 2025, 9 a.m. or as your invite indicates, bond will continue.
Thank you, Your Honor. Everyone have a great
Thank you,
day.
Your Honor.
All right, thank you, folks. Take care.
You too.
Oh, you guys are leaving. You messed up my whole day and now you're out. All right, bye. No, I'm kidding. Court calls the case. People versus Isaiah, is it Levy?
Ashley Lundy for the people.
Alex Pedraza standing in for Mohammed Nasser on behalf of Isaiah Levy.
Okay. Your name, sir?
Isaiah Levy.
All right. All right, what are we doing?
We are setting this matter for a preliminary examination, Your Honor.
All discovery is complete, counsel.
Yes.
People had their witnesses available on the 13th.
Would the court mind going to the 20th if it's?
You have any objection?
No, Your Honor.
All right. Preliminary examination in this matter, May 20th, 2025, 9 a.m. That is before Judge Barr. Bond continued.
Thank you.
Thank you.
Thank you. And court calls the case, People versus Kathy Johnson.
Rachel McDuffie for the people.
Counsel, you may want to unmute.
Kathy Johnson.
All right. Who's the attorney, right?
Timothy.
All right. Mr. Henzek? We can't hear you. If that's you, I don't. Ms. Johnson, is that your attorney, Mr. Henzek?
Yes, I just seen him and yes.
Okay, and he needs to unmute, but.
Wow.
Oh, there you go.
Finally.
Finally, yeah.
Good afternoon, Your Honor. I am Tim Hemphick, and I do represent Kathy Johnson, who is joining us on the Zoom hearing today.
Yes, ma'am. All right, and she has introduced herself. All right, what are we doing on this case?
Your Honor, I discussed potential resolutions with Mr. Hensick over the past week. We have a referral form to the 14B Recovery Court for screening. I've signed it. I did copy, I sent a copy to Ms. Whiteling last night. I think that Mr. Hensick may need to fill in a few more blanks, but if the court is willing to sign it with what we have, we can have him do that and forward it to 14B.
I have signed it. I'll sign off and then let me adjourn then the probable cause hearing, see where we get to May 22nd, 2025, 9 a.m. or as your invite indicates. And the defendant's bond will continue.